the item number, but today the matter
It's
is
not appearing.
No, but
Why?
they have taken out the matter for listing, but it has something has they have missed, I think.
লিস্টে নেই কেন?
Yes.
আচ্ছা, তাহলে ওটা কি একটা This is expiring or
Today,
tomorrow?
Today it is expired.
Who is appearing for the other side?
I'll bring him. On the last date they appear.
এটাকে একটা কাজ করুন, একটা সাপ্লিমেন্টারি
Other matter, Malad. This is preemption, Malad. This is Jalpaiguri matter that I am mentioning.
জলপাইগুড়ি.
Yes, your lordship is there from Monday, but
Yes.
I'll be mentioning that also on Monday on virtual mode also, Malad. Malad, with regard to our
Mention
OBC Malad matters, Malad, where
mention জলপাই. Yes.
Great comparison, my lord. I was mentioning item number 691. Like this, well, 27.
My lord.
Well, 27th is the date, my lord. There, my lord, on order 22, an application in the queue for partition has been allowed by the learned trial judge, defying the order of injunction. My lord, your lordship,
Order 20 Rule 10 is an appellable order, Mr. Ghosh.
order 22, rule 10 application, infringement, order 1, rule 10. Order 22, rule 10 application.
Order 22 Rule 10 is an appellable order.
My lord, if you logic kindly check order 6, rule 17, allow it.
Order 22 Rule 10 is an appellable order. How a revision is maintainable?
Order 22, rule 10, at the instance of the application, the order 6, rule 17 is also there.
Maybe, are you challenging Order 22 Rule 10 or only Order 6 Rule 17? Order 22 Rule 10 is an appellable order.
Order 22, rule 10 application, my lord.
Then it's refusing or grant leave, both are
Order
appellable.
22, rule 10 is applicable.
Then you want to withdraw?
That's the withdrawal, my lord.
এই ওটা পার্ক করে রাখুন।
That's the withdrawal.
1 PM item number
691.
item number 691 টা পার্ক করে রাখুন। 1 PM করে
Your Lordship, may I
Lordship, may I
permit
be permitted to mention one matter, Lordship? This matter is to be appear in the list of 15th of July of this month, but it will not appear, and the interim order are going to be expired, Lordship.
when it
Kindly.
is going to expire?
This month, this last day.
Lordship, may I permit it? Your several times your Lordship mentioned the application next date is fixed 27, last date, your Lordship. My
For what?
cross-examination of the defendant number 1, your
What is
Lordship.
the order impugned?
Impugned order is two application you have filed, one for repairing application, another for cross-examination of the commissioner, your Lordship. Both have been rejected by Lordship. Several times paid adjournment, cost imposed by upon
Examination rejected.
cross-examination, recall of the further commissioner, your Lordship.
Yes, so.
Your Lordship, I am paying for several. Your Lordship is a next.
Hand over the slip.
Your Lordship, your Lordship, I am suffering. My client is suffering very
You
lot.
have cross-examined already. Who is your client?
In the court premises, your Lordship.
So you have all. You have already
My
cross-examined.
cross-examination will be close, your Lordship. Close, your. I have filed an application for
Sir, the impugned order is to recall the advocate commissioner for to cross-examine him. You
cross-examination,
have already cross-examined him.
but rejected, your Lordship. Some
Rightly rejected.
because rightly because the
No urgency. Yes.
because
Our prayer is only that there are four applications pending before the learned lower court. If my lord just grants that for an order for expeditious hearing, that would suffice, my lord.
Expeditious hearing of the suit, madam. No urgency.
my lord, I have several times mentioned your 2000.
My lord, may I be permitted to mention one thing from Jalpaiguri?
Yes.
I have filed
Yes,
a
Mr.
contempt
Vasu.
application.
Yes.
I have filed a contempt application for non-compliance with your lordship's order.
Yes.
Directed the municipality to inspect the site and take appropriate action. But in spite of that, they didn't comply the order.
Please
of the
mention on
learned-
Monday, Mr. Vasu. Please mention on Monday. Yes.
Permitted to mention this matter,
my lord, the file is at Calcutta principal bench.
Please mention. Please write a
kindly
letter
write
to the. Please write a letter to the registrar circuit bench for transmission of the records. Yes.
Item number 2183 of the monthly list, my lord. My lord, this matter was substantially heard before Justice Rai, my lord, if your lordship kindly, my lord, allows this matter.
Upgradation, please hand over the slip.
Lord,
mentioning the
item
RTC.
number, Lord, item number 694, my lord. 4th of August is the date fixed for acceptance of additional written statement, my lord. Challenging the order of amendment, my lord, I have come up before your lordship, my lord. 4th of August is the date fixed for acceptance of the additional.
It will be done. It will be accepted.
No, my lord, it will be accepted.
Hand over the slip, yes.
বলছি স্যার পিটিশনার ইন পার্সন স্যার একটা ম্যাটারে স্যার রিলিজ চাইছি কাইন্ডলি স্যার যদি রিলিজ
Yes.
করে দেন
My lord, may I mention for upgradation of the matter? Lordship, it is appearing as item
Please
number.
hand over the slip mentioning the urgency. Yes.
Item 209, my lord, some urgency is there.
What is the urgency, Mr.
My
Mitra?
lord, the execution case is on 18.
What is the order under challenge?
The order under challenge, the miscase has been initiated at the instance of the judgment data. And my lord,
Discuss under order 21
order 21, rule 97-101,
by the
they are-
judgment debtor or by a third party.
or by he is claiming a third party that he has a
Party. That's maintainable.
my lord,
What order you are challenging?
my lord, an amendment. Thereafter, my lord, he is withdrawing all the admissions, my lord, whatever made in the original.
Amendment allowed. Hand over the slip. Yes.
My lord, I am giving this.
Yes. Yes.
Your Lordship, may I be permitted to mention a matter for upgradation, Your Lordship? Lordship, we are at the stage of cross-examination. We had filed an application for appointment of an handwriting expert. Now, the learned judge had rejected.
Rejected.
Yes, Your Lordship.
Hand over the slip. Yes.
My lord, may I be permitted to mention one matter? My lord, in the trial court, I have filed a order 6, rule 16, and substitutional portion of
What
the.
do you want? Upgradation?
My lord.
Hand over the slip. Yes, call the list.
Why this will be released, my lord, I do not know. Why lordship has never appeared. This matter has been substantially heard by the
Who
other.
has mentioned for release?
I have mentioned, my lord, this,
Why?
my lord, this, if my lord goes through the
Not been
orders
parted.
of,
I have the orders, and after 4 months, my lord, today they were
it was
mentioned.
for fixed orders and it was substantially heard by.
He's disputing that.
No problem, my lord. My lord might fix it any day.
You can hear about the matter, but why?
Yes, my lord, I have no objection if because it
not
was.
parted. Lordship will see, and that order was passed in March, and today we are in the month of.
Because it was running in the list of Justice.
Ashwin, this matter.
Yes. My lord, this matter was mentioned by Mr. Nag yesterday, my lord.
Yes.
My lord, 2 civil revisions, my lord, challenging the same order. My lord, one is before Justice Sharma, my lord. My lord, one is before Justice Dinesh Sharma, my lord. It has been substantially heard, so we were praying if both the matters could be.
What is the other number?
Both the numbers are mentioned in the order sheet, my lord. Well, CO 4504 is before Justice Sharma, and the one mentioned in the order is before your lordship of 2026.
It has been submitted by
My lord, learned advocate Mr. Shaunak Bhattacharya appearing other side, opposite party on behalf of the opposite party's caveat is there. So I'm praying for release this matter.
In which order he appeared?
Order 7, June 11, my lord. Reject,
You have the order, copy of the order.
the order is annexed in this matter.
Which page?
Number 43.
243.
Starts from 243.
3. The last page is 242.
Oh, my lord, last page is 46 is here.
In,
Designation is my lord.
in the impugned order, his name is not here.
Order is here, my lord.
Please check
There
up.
is annexed impugned order, my lord. I am.
Yes, please check up. Pass over next.
Yellow.
Yes, yes.
The preemption application, my lord. Registered deed executed in the year 2011. Application filed 2013.
What ground?
Co-sharership. Even if, my lord. Non-notified co-sharer. This is maintainable.
What happened?
Allowed.
Preemption
Application allowed.
like a appeal, Mr. Right.
And that is why, my lord, already. This is the point. No, my lord.
For the respondent.
What do you say?
Worship, I am led by Mr. Sajan Hussain. I am led by Mr. Sajan Hussain. He is not able to. Problem.
Mr. Rai, please show me those only
Yes.
that limitation, how it has been dealt with.
Yes. If your lordship can turn to the application once.
All right, when it is expiring?
July. Subject to correction, my lord.
End of July.
Yes.
So making it end of August.
Yes. This is the point. Otherwise, well,
in extension, it can be taken up. So I'm fixing it. I'm extending it till the end of the month of August. Be prepared with that. Yes, please come ready with the main matter. The interim order. Yes, next.
My lord, I am for the opposite party, my lord. My lord, in this matter, I am led by Miss Lavanya Suchina. Kindly allow her.
You have got the judgment, Mr. Halda.
This judgment is not applicable in the facts and circumstances of the instant case. Because in the instant case, my lord, the suit was filed against the original tenant. Suit was filed against the original tenant.
Where? In this matter?
In this matter.
And in your matter?
Suit was filed against tenants in common. Just as the Honorable Justice Bhattacharya has distinguished it and says, my lord, in case of tenants.
Please take me to that. Where is the plaint?
My lord, plaint, my lord. Annexure A.
Yes.
Page 7, my lord.
Page
7.
Page 7, yes.
Paragraph 1, my lord, plaintiff is the owner of premises number such and such. Paragraph number 2.
Of the defendant number 1.
Srimati Leela Devi Nangalia, since deceased,
was inducted
as a tenant by the plaintiff in respect of one self-contained flat situated at the rear portion of the ground floor, consisting of 2 bedrooms, 1 sitting room, storeroom, kitchen, TV, being premises such and such, at a monthly rent of 400 payable according to English calendar month, and the said charge is held on called as property. Then we'll kindly turn to the next page, paragraph 3, that at the time of index said Leela Devi Nangalia paid 1 month. Then kindly skip over to paragraph number 4. That the said Srimati Leela Devi Nangalia died intestate in the month of December 2018. And at the time of her death, she left her husband Govardhan Das Nangalia and one.
Where is the distinction, Mr. Haldas? Please
Yes.
show me this.
Well, kindly have a look at the reported judgment of Honorable Justice Bhattacharya, paragraph 4, page 410.
Yes. Paragraph 4.
Paragraph 4, my lord, the learned
Yes.
submits that by virtue of the said amendment, plaintiff sought to make out a ground that the defendant petitioner had become a trespasser by operation of section 2G of the Act. It is argued that the plaintiff in the original plaint categorically averred that the petitioner and the other dependents are tenants in respect of the suit property, not by inheritance or as tenants in common, but original tenants. Placing reliance on paragraph number 2 of the plaint, learned counsel for the petitioner argues that no tenancy in common was claimed, but it was averred.
Where is the distinction of tenants in common?
Yes, my lord. Kindly have a look at paragraph number 25, page
Yes.
412. As far as the decision of the division bench of this court rendered in 2017 1 CLJ in Utpal Rai and another versus Ratul Krishna Banerjee, as well as the judgment reported in 2019 volume 2 CHN Chanda Mojumdar versus Navakumar Mojumdar are concerned, both deal with the cases where there was a tenancy in common created upon the date of the original tenant, as had been originally pleaded in the plaint, unlike the present case. In the present case, the consistent pleading of the plaintiff was that the defendant were original tenants. Moreover, it is evident from the plaint that the rent was received till the year 2013, much after the lapse of 5 years from the commencement of the statute, which without a ground of default in payment of rent having been taken. So,
Yes, Mr. Bhaldar, I've seen the distinction.
yes, my lord.
I've seen the distinction, Mr. Haldar.
And my lord,
it may not apply, but the proposition will apply.
But this proposition is not applicable here, my lord, because I have not, after the date of the original tenant, I have not, my lord, accepted them as a rent. I have not accepted any rent from them. I have not, my lord, accepted it as a tenant under me. My lord, I have filed, my lord, against them, my lord. The
question is whether that's one way of looking at it. Other is whether a suit under section 6 can be converted to a suit under section 2G. It says it cannot be done. Nature and character will be changed. That's the ratio of this judgment.
My lord, in the instant case of, my lord, in the Utpal Rai, but division bench says, my lord, in case of, my lord, eviction of a tenancy in common, my lord, section 2G will come by operation of law. And in the, my lord, Chanda Mojumdar case also, my lord, the similar view was taken.
Yes, Utpal Rai. Yes, and what is the other judgment?
And my lord, in the case of Chanda Mojumdar, just in the instant case also, my lord, suit was filed against the tenants in common by inheritance, admitted fact. And my lord, in the said case, my lord, 2G was applied by way of amendment that has been allowed.
Till 23. So this is the prior judgment. It was not considered. Chanda Mojumdar. Yes, Chanda Mojumdar was considered here.
Considered, but
was also considered.
yes, yes, considered, but the factual is different. In the case of my lord, Shomir Kumar Kundu's case, my lord, the suit was filed against the.
Who is leading you?
Lavanya Sinha, my lord. She is online.
Where is he?
She is online, appearing online, my lord.
My lord, I appear, my lord, for the opposite party. Am I audible, my lord?
Yes, yes. What
My
is your
lord,
submission?
My lord, my only submission is that whether it be a case of original tenancy, whether it be a case of tenancy in common, whatever may be the facts, lordship, today, if this amendment is allowed, it will essentially give rise to a fresh suit. So only the cause title remains the same, and the averments, the plaint, the relief, everything changes, lordship. My most respectful submission is whatever be the nature of the amendment, whatever the law may allow, has to have regard to the provisions and the principles of Order 6 Rule 17. My lord, the nature and character of the suit is changing. The characterization of the defendant in question is changing. Most respectfully, my lord, that cannot be allowed.
This is appearing where, Mr. Haldar?
My lord.
Today it is appearing under the heading
Extension of
but it was appearing where? Under which heading?
extension of interim order.
Today it is appearing under the heading extension of interim order. Previous to that, it was in the list.
It was in the list.
Under what heading? Where? Combined list?
Combined list, my lord.
Under what heading?
New motion.
New motion. The interim order is extended till the end of the month of
Item number 7, my lord. I appear on behalf of the
This is appearing at our instance, my lord, for extension of interim order.
Yes.
My lords, I am appearing on behalf of respondent, my lords.
Yes.
My lords, this matter arises. The petitioner has filed a writ petition, my lords, under Article 227 against an procedural order, my lords. My lords, the arbitral proceeding has been stayed for over 1 year, my lords. My lord, we are just requesting a fixed date and time, my lords, for this case.
The
My lords.
interim order, after hearing the learned advocates for the respective parties, the
Obliged.
I'm from the petitioner. I'm paying for one.
Can 1 was for extension.
Can 1 they had filed for early hearing and for vacating of it.
My lords, if I may, my lords, the time
Obliged.
has been fixed, my lords, in this matter, my lords.
Yes, it was appearing in the list under what heading?
Extension of interim order.
No. Prior to that.
Adjourn motion. It was heard on 2 occasions.
Let the matter retain its position. Let the matter retain its position in the list. Yes.
My lord, I'm from the petitioner. I'm paying for 1 day accommodation, my lord. Not today only.
No, not today business. Yes. What is this matter?
Matter is for custody, my lord.
Yes.
Challenging the impugn order dated order number 5, dated on 17/3/2025. The father filed the custody against his mother for the minor child, and Thule number has been filed between the father and mother. Thule number has been filed already between the mother and father, but on the meantime, again parents are injured, and they filed the order 10 rule 2.
Order 1 rule 10(2) for what?
For grandparents.
Grandparents will be implemented. Why?
For that reason, I am challenging the order, my lord.
That has been allowed.
Yes, my lord. On order dated 8. 17 order dated 8 19/09/2025.
19th July.
1909, my lord. September. Order number 8.
Where is the application under order 1 rule 10?
Applications, my lord, page 29. Full number has been filed, my lord, page number 27.
The learned advocate appearing for the
Happy for the petition. Petitioner, my lord, filed an application for restitution of conjugal rights. In that application, my lord, he filed an application under section 36 of Special Marriage Act, my lord, kindly come to page 90, wherein, my lord, in 2014-15, alimony of 2,000 per month and 5,000 litigation cost was awarded. But that was not complied. Although the petitioner did not take any steps, my lord. Subsequently, kindly come to page 21. The application under restitution of conjugal right was dismissed.
dismissed on merit.
So dismissed for default, my lord. She was in a financial stringent condition, could not pay, do anything. That during the suit was dismissed.
Yes.
Husband filed with the application of restitution of conjugal filed written statement as well as counter claim praying for divorce, my lord. Now that counter claim proceeded, my lord. In that counter claim, my lord, I filed an application under section 36, praying direction that the order.
You filed an application under 36.
Yes, I filed
Yes.
an application in the counter claim itself. That praying, my lord, that the order of alimony passed in the restitution conjugal will be continued in this proceeding also. That was turned down by the court below.
What was your application? Please show me.
And kindly comes to, my lord, page 22.
The initial restitution suit was filed by you.
My lord. Husband filed the written statement as well as counter claim. The counter claim he filed for divorce, my lord.
The miscase, the section 36 was registered as a miscase. Then it is not registered as a miscase if an order was passed in that suit. So you could have prevented that without payment, suit could not have been withdrawn.
So that was whatever is done, my lord. Kindly see, my lord, in the application itself, petitioner is not in a such financial position, also not properly advised and proceeded. Now, my lord, the counterclaim is
The
proceeding.
issue that arises for consideration.
The order was passed in 2025. Yes, well, but due date it has not proceeded, date for fixed for written statement. I have tried to give an explanation in this revision application also, saying that what prevented me from preferring the revision application.
Uh, Paragraph কি বললাম the
It cannot be touched also. If my kindly fixes a date.
let it appear thereafter. Yes, call the next matter. Yes. None appears for the petitioner. To this
My lord,
yes.
in this matter, in earlier occasion, my lord, Mr. Sonak Bhattacharya appeared, my lord, and
I'm not inclined to take up.
Item 12, my lord. I have gone through the application. This is appealable order. Section 5 rejected in connection with the appeal. But my
Section 5 in connection with title appeal. The learned advocate appeal.
হ্যাঁ ওই যে
Think none appears for the petitioner at the time of
routine appear for the petitioner arising out of DRT or order passed by DRT. Your Lordship kindly peruse why you have
appeal
come.
lies, Mr. Bhattacharya.
Why you have come before us? Just see, madam. The unscheduled date matter was taken up for hearing and dismissed for default. I have filed an application for restoration that has, without considering, that has been disposed of, dismissed. That has been dismissed.
Restoration application has been dismissed
without considering the notice, my lord. Your Lordship kindly peruse page my lord 41. Scheduled date for DRT matter was July 2023. Your Lordship kindly sees the date up, and your Lordship kindly sees the when the matter was taken up for hearing. Page 25, 25th July. This is not the scheduled date.
Page 25.
Yes, sir.
But 25th July is in DRT 3.
DRT 1, DRT 3. This is DRT 1 matter. This is DRT 1 matter. Your Lordship get at the top. Date Recovery Tribunal 1, Kolkata.
But please show me the order of dismissal is this.
Page 25. None appears for the surface applicant. Learned advocate Mr. Om Prakash Ganguly appears for the respondent. Prays for dismissal of the essay as not appearing. TA dismissed for default. But I have filed, I have annexed the notice that has not been considered, the schedule of notice board.
And what is the order passed on the restoration
Yes.
application?
That is not that page. Impugned is. (11 June 2026). Even not considered this notice, perverse order, my lord. Yes, observed, we have not appeared. None of the occasion till date, there is, it has been adjourned only at the instance of the court. and this notice has not been considered. If I go before there, my lord, unduly burdened, I have to pay stamp duty of rupees, my lord, 1 crore 50 lakhs.
Who is appearing for Canara Bank?
And here I do not know, my lord, your lordship, new motion, your lordship, I served notice, my lord, the 2 weeks after.
Mr. and Mr. and except new motions, it will not be taken up, Mr. Bhattacharya.
The very difficult matter. And I have mentioned on a matter, my lord, not being unable to. I filed it before the vacation, last day before the vacation. It was not taken up for you.
Yes.
And court is overburdened, my lord. I cannot blame the court also. But
Yes. This is the plaintiff's application for expeditious disposal of a Section 151 application.
151 for what?
This is for payment of maintenance by the defendant, who is the father to the child, my lord. This is a suit for specific performance of a contract, my lord.
Specific performance of contract, payment of maintenance.
My lord, what has happened in a matrimonial suit, my lord, the divorce was granted and a settlement terms has been agreed upon by both the parties, which has been registered. Now, based on that, the father was supposed to pay certain amounts of maintenance, which the father is not giving, my lord.
The learned advocate appearing for the petitioner submit.
My lord, Mr. Devashish Saha is
My lord,
appearing.
my lord, I am appearing, my lord. I am appearing, my lord.
Yes, sir.
My lord, this is an application for early hearing of my application under Order 7, Rule 11, my lord. The suit has been filed by the borrower, who has filed very many applications and suits in very
Section
many other
34
courts.
bar under section 34.
34, my lord, bar under 34.
This application under Article 227 of the Constitution of India. Submits the next.
And I am the petitioner. Lordship, it is expeditious complete the trial, Lordship. The evidence has been fixed.
Who are you?
I am the petitioner, Lordship.
So that I appreciate, but
I am the wife, Lordship.
Wife,
Yes.
plaintiff of the defendant.
Plaintiff. In my suit, Lordship, I filed a suit for dissolution of marriage. The husband, opposite party, Lordship, he also filed an application for
Application
contract.
under Article. Yes, call the next matter. Yes.
The permits. Expeditious hearing, Lord, permits.
Application for expeditious disposal, your Lordship. Suit for
Expeditious disposal of what?
suit for eviction and recovery of possession, your Lordship. Decreed, dismissed, your Lordship. Appeal preferred, appeal allowed. Then we have preferred an execution, your Lordship. During the execution, SLP was also dismissed. They preferred an SLP dismissed. And the two miscases are pending, your Lordship.
Miscase under?
Order 21, Rule 97, your
Two
Lordship.
miscellaneous case.
Yes, one they preferred, Order 21, Rule 100, they preferred, your Lordship. We preferred for Order 21, Rule 97, your Lordship.
Order 21, Rule 101 is, what is the number of the miscase?
5230.
5230.
That is our, and there is, we haven't received the copy, your Lordship.
No, their application I think is 5230.
No, that is our application. Their application, kindly see the order dated 7/3/2026.
Yes, but it has not been registered.
So the difficulty is, Lord, it has not been registered one.
And the other factor is, my lord, there is fault from my part also. My lord, this should have been a application under simpliciter section 208. My lord, kindly records that, my lord, because else again, my lord, that same story will begin.
This application under Article 227. Limited
Should
evidence.
not take more than 4 months. Should not take more than 4 months.
As expeditiously as possible, but preferably within. Next.
I am for the petition.
Yes, madam. Have you got that? Item number 3 টা done.
So the order is there, but pagination have not done. If you permit, my lord, then.
No, you cannot put pagination. Please show me the page where he has appeared, you said.
Oh, yes, my lord.
Where is that?
My lord, kindly see number 200.
200.
In this matter,
Since I'm not inclined to take.
I am for the petitioner, my lord. But opposite party plaintiff filed a suit for declaration mandatory injunction. But can you see impugned order? And what petitioner claiming that the defendant, he has allotted 2 decimals of land for his residence.
Please give me a minute. Please give me a
But,
minute.
the petitioner's plaintiff says that he is in possession of plot number 1454.
Please give me a minute.
But, kindly come to page 24, the application which I have filed. Page 24.
Written statement, written statement.
Written statement is not with me. Written statement. I have annexed that, wherein I said I am residing in plot number 1009, my lord. This is my condition.
So according to you, you are residing in plot, you have right in respect of 1009 and not 1454.
Yes, my lord.
Prove that can be proved by way of a documentary evidence. It's a suit for eviction of a licensee.
My lord, may I play one? Kindly come to page 22. So
22.
2 is the record of right of the plaintiff.
Yes, 1454.
Next page, my record of right, my lord. Can you see?
Yes,
Page 23.
1069. Separate.
Yes. Separate. But so we prayed for appointment of survey.
It is adjacent plots.
Adjacent plot.
Where have you stated that it is adjacent plot?
Can you see? Yes. It is not visible, page 27, but
it's a different plot.
Adjacent plot, because
maybe
it became a Bata Dag. It became a Bata Dag of 1454. So it is Bata Dag created. So I am in 1009. So it is adjacent land matter. That's why problem created. So it is demarcated by Advocate Commissioner. That will be if you kindly consider this, because otherwise it cannot be taken by evidence to prove this. But it requires for local inspection in which plot I am residing, my lord.
You are residing in 1009. There
Yes,
is no
but-
difficulty.
but-
And they will get a mandatory injunction on 1454.
My lord, only
That will be their headache at the time of execution. Reserve that now. This application under Article 220.
on Monday. On
Adjourn for this week.
this week.
Next.
Plaintiff petitioner before your lordship, my lord, before submitting my case, my lord, I should submit, my lord, this case was filed by craving leave to file a certified copy. I am not getting this.
You have not got the certified copy. Why?
My lord.
This is an order of 2nd December 2025.
Yes, absolutely. I filed this application for certified copy on 28th. It
28th
was 28th of January. It was filed on 30th January. This revision application filed on 30th January. My lord,
Yes, what is this matter?
My lord, this matter is nothing but, my lord, my cross-examination to the DW. My lord, since my mother was in ICU, I prayed for time. My lord,
what happened on 2nd of February 2026?
2nd February 26, my lord, argument was there, my lord, argument partly heard by the, my lord, on behalf of the defendant. We prayed time, but no time has been granted. Next date is, my lord, coming week. My lord, they will conclude the suit, my lord. Kindly pass some protection, my lord, otherwise, my lord, I'll be helpless, my lord, because only one day I have been partly cross-examined when the evidence has been completed of the DW. That is the previous date, only 31/9/2025. My lord, they took, my lord, 11 dates for examination of DW. Well, only one date I am accommodating since, my lord, the previous page of the impugnator, kindly see, my mother was, my lord, in ICU. And page 22 is my application for adjournment, but only these grounds, my lord, I am taking adjournment, my lord, but court decline my adjournment, and, my lord, these things has been happened, my lord. I will be, my lord, there will be.
Where have you stated that your mother was in ICU? For that you have, where is your application?
Yes, my lord, page 22, handwritten application. Yes, my lord, job at Charnock Hospital, my lord, second paragraph, 1, 2, 3, 4, 5th line. And next page is, my lord,
the order impugned. By the order impugned. line, yes. On the verbal prayer of the learned counsel for the defendant, their evidence is closed.
But I am the plaintiff. I am the plaintiff, my lord. This is the defendant. I am the plaintiff. This is my suit. This is their prayer.
This is that matter, my lord.
Very strict. Today?
Not today. No.
Not this week. Brother.
No, not this week, my lord. Yes, stay of operation, my lord. I have come up with a solution, my lord.
All right, not today.
Not today, my lord. Thank you.
Yes, next.
22, I am for the petitioner, my lord. This is my application against the order that when my application for that eviction under as the original tenant died after 5 years, 2G application has been turned down, my lord.
The application has been turned down.
Yes, my lord.
I have instructions to appear, Miller.
Yes.
Let them serve a copy.
Serve him a copy.
We have served them. We have served everyone.
We have not received.
I have served everyone, my lord. This is affidavit of service.
It was directed to be served. Yes. Yes, where is the impugned order?
Served them though, but I can definitely serve them. I guess. Initially, suit has been filed, my lord. In my claim, there are specific avertment, my lord, that
Suit
others
filed. Please show me the plaint.
Yes, my lord. Page is from page 21, my lord. And we have specifically the suit has been filed due to 2015, my lord. The original tenant died on the March month, and in the November month we have
Suit filed against the original tenant.
no, my lord. The heirs of the original tenant.
The heirs of the original tenant.
And specifically
When the original tenant died.
in the March 2015, my lord. And suit
March
has
2015.
yes, my lord.
And the suit filed when?
November 2015, my lord.
November 2015 against the heirs.
Against the heirs. But
Against
there
the
is
heirs.
specific avertment that none of the defendants are the dependent upon the defendant, the original tenant.
Commercial tenancy or
Residential tenancy.
Residential.
Initially, suit has been decreed. Only the son has been appeared, but they have not
Decreed.
Initially decreed. Son appeared. There are three defendants. One son appeared. 7172 has not done. Thereafter, suit has been decreed ex parte. Thereafter, they have filed. Daughter has filed an application under Order 9 Rule 13 that has allowed. And thereafter, the suit got restored. Now, my lord, the specific award.
Now you file an application under
2G.
2G.
It's supposed to be, my lord, judgment upon admission also, but it has made us 2G.
Judgment upon admission.
My lord, the tenant, the defendant.
Amendment application has been rejected.
Yes, my lord. There is specific amendment, my lord. Kindly come page 43 is the application of the present, my lord, defendant, who is actually contesting, my lord. Page 43. The petitioner married Dilip, may I read, my lord? That is the contesting defendant's avertment. Reside in the place of the servant who used to work. A in Borakhana 1982 to 2010, in Dhanbad 2010 to 2016. So at the time of death of the original tenant, neither she used to live with her and she was dependent on her husband. And after that, 5 years also expired, my lord. Nothing remains in this suit.
Okay.
Not in this
He
suit.
says nothing remains in this suit.
Not in this suit. Not in this suit.
This is the suit.
March died, November suit filed. Where is the cause of action?
Well, during the pendency 5G, my lord, applied. There are, my lord, judgments. Your lordship, judgments are also there.
With the judgments.
Yes, my lord.
ফেরত এসছে তো ফেরত এসছে সব
বাবা এটা আগে এত দিয়েছি আবার এই চেক করতে আমি কপি দিয়ে দিচ্ছি I read, my lord. Acceptance and rate is, my lord, cannot be a ground for, my lord.
এফএটি কত দিদি এফএটি
413. Son and mother never come, my lord. Only the daughter has come. And may I, my lord, before going to the judgments, my lord, may I go to the awardment of the plaint once?
Please give me a minute.
May I please the plaint
No
once?
amendment, then why amendment?
Amendment, my lord, I have not prayed for amendment, my lord.
Then,
I prayed for decree.
no, what is the application which has been
2G, my lord, that since the,
Oh, 2G decree.
my lord, since that is the reason I said, my lord, it has to be under, the caption should be, my lord,
Sorry, I was under the impression that you have prayed for amendment.
No, my lord.
Uh,
Because, my lord, my specific awardment in the plaint is there, my lord. That is the reason, my lord, I am emphasizing on the plaint, my lord. Please come page 27, my lord, in the plaint.
7, yes.
Paragraph 9. The defendants were not ordinarily living with the original tenant. Anil Chandra Vishwas, up to the date of the tenant, as the members of his family and defendants were not dependent on him. Because the defendant number 3 and 4, defendant number 4 of the Anil Chandra Vishwas were all married and living their matrimonial houses. That is accepted by the defendant number 3, is the contesting defendant right now. The defendant number one, son Alin Chatra Vishwas, have two separate shops with his name, Interior Beauty and Beauty Tailors, both with the Barashat police. Extracting
Where
the
is your application?
well, at page 42.
Para 7, my lord, they says, my lord, section 6 notice was served upon me.
Page 58, my lord, paragraph, annexure P7.
Page 58.
8, my lord. This is a commercial property, my lord. I initially state, my lord, this is a commercial property. The contesting daughter was living with her husband at the time of
23 lawsuit. I am appearing on behalf of the plaintiff petitioner lawsuit.
Yes.
Suit for declaration of title and permanent injunction. Initial injunction order was there. Thereafter lawsuit. Impugned order is the extension of injunction order was rejected as well as suit dismissed.
Suit dismissed.
Lawsuit. On the why lawsuit. Initial injunction order was done lawsuit in the year of
Where is
2000.
the impugned order?
Impugned order lawsuit February lawsuit last 17th February 2026.
Then you have to restore the suit.
No lawsuit. Lawsuit kindly come to the third paragraph, fourth and fifth. Initially, a suit was dismissed for default in the year of 2017.
Fifth paragraph of what?
Impugned order. Initially, suit was dismissed in the year of 2017.
Yes.
I have no knowledge. Thereafter, suit was proceeded. Date was fixed one after another. 2022, suit again suit was dismissed. I praying for time. So-called reply, giving so-called reply. That was rejected and suit was dismissed. I filed an application order 9 rule 9. That was allowed. Thereafter, I filed another injunction application. That was at interim was passed. Thereafter, filed an application for extension. On that day, defendants saying that the earlier 2017 was dismissed, so the suit was dismissed. My contents are there. 17 order dismissal order, I have no knowledge. Thereafter, suit was proceeded. Second time dismissed order in the 2022. When the second time 2022 was dismissed, the first dismissal order was clubbed with the 22 order dismissal order because death suit was proceeded without knowledge of my also without knowledge of the court. And second time 2022 also dismissed. I restored the 2022 order. Defendant not come and not pointed out that. And I have no knowledge.
No, you are challenging the 2022 order. No, thereafter what happened?
Thereafter suit was
where is the 2020
lawsuit I entered first order lawsuit 14th November 2017. First dismissal order lawsuit 14th November 2017. Got it lawsuit. Today is fixed for filing so coach by the plaintiff. Plaintiff takes no step. Learned advocate on behalf of the defendant. Separate by filing Hajira. Neither any so coach nor any step taken by the plaintiff on call. Hence, it is ordered that the suit filed by the plaintiff is dismissed for default. Thereafter, lawsuit I enter order sheet was filed. Thereafter, next date, plaintiff is absent without step as per the resolution of the local bar. The case is adjourned. Next day fixed. Thereafter, lawsuit one after another date was fixed up to 2022. Next dismissal order lawsuit 16th December 2022. Registration order টা কবে দেব? Second dismissal order lawsuit 16th December 2022. Today is fixed for filing so coach by the plaintiff. Plaintiff files a petition praying for time for filing so coach. On perusal of case record, it appears that the suit is pending at the stage of filing so coach since 19th January 2017. As such, it is clear that the plaintiff has no intention to continue with this suit, and this is a perfect example of wasting the valuable time of this court. Thus, the time petition filed by today by the plaintiff is rejected. Hence, it is that the suit be and same is dismissed for default. Thereafter, lawsuit, I filed an application order 9 rule 9 also section 5 on 28th April 2023. Order dated 28th April 2023. application under order 9, rule 9, along with section 5 is received from the central filing section, register court fee paid, requisite put in, process fee paid, issue the same. SR, next date SR. Thereafter, lordship, restoration order, 21st April 2025.
By the order impugned, the
Petitioner. The petitioner is a defendant, my lord, in a suit for declaration and injunction. That initially, the identity order of injunction was rejected by the trial court.
What is the
Thereafter-
order impugned?
Yes, madam, I'm coming to that. Thereafter, they preferred a misappeal, the plaintiffs, and they got an order of injunction in the nature of restraining me from raising my construction. Now, my lord, in the plaintiff has admitted that I am the owner with respect to 12 decimal of land in the middle portion of the suit plot. Now, I am not constructing, but my repair work is going on. By this order, impugned order, my lord, the entirety have been stopped. But I am here before your lordship today only to clarify that I can make my construction, or rather the repairing work, in my plot of land. But if my lord kindly takes up their plaint at page 17. My lord, paragraph number 3, my lord kindly turns it over at page 18. My lord, I am
that appearance in the miscellaneous appeal.
Perhaps no. Yeah, miscellaneous appeal. No, my lord.
Is enter appearance in the miscellaneous appeal. This is a short point. I'm directing the appeal, miscellaneous appeal, to be disposed.
But my lord, the next
cannot be modified without hearing the other side.
But my lord, kindly takes up their plaint for once. Kindly takes up.
Please serve, then it will be kept pending unnecessarily here. Or I can direct the miscellaneous appeal. You take all points there. There you can file an application paying for leave to carry out the repairing work.
Then kindly,
it will be easier for you to get an order of repairing work from there.
And then kindly records my submission, will not give me liberty to. Because my lord, in the plain will
the expeditiously as possible without granting any unnecessary adjournments to either of the parties.
My lord, and kindly observe it, my lord, that it is on my instruction that my lord directed me to file. My lord directed me to file the application before the trial court, my lord.
Then I will be proceeding on merits. I'm
My
not
lord can
directing you.
proceed.
I've only
Very
asked
well,
you.
very well.
It's your submission, I have not directed you. It's after all, otherwise I will decide it on merits. Yes. Yes, next.
Your Lordship, Mr. Devjit Mukherjee is appearing in this matter for KMC. Mr. Devjit Mukherjee
is appearing for the KMC.
he has not come to the court. I'm praying for not today, Lordship.
No, can you see the last order? I don't know whether they've complied with it.
Yes, yes, yes. Supplementary affidavit which you have
We
prepared.
haven't been served.
Yes, it has been served.
কাকে serve করেছি?
করা হচ্ছে তো।
এইটা আমার।
ব্রিফটা কোথায়?
Have already been served. That order records have already been served upon the learned advocates for the opposite
No,
party.
there's a new one.
What new one? No, I want. There was only one direction to bring the original.
The order records it has been served. Already been served.
Lordship, there is a
That's the
supplementary
expression which has
affidavit.
been used.
There was a direction, my lord, to bring the original order passed by the learned tribunal. Original order of demolition which is under challenge passed by the tribunal is it? Should be ordered term কথা ছিল। Copy নিয়ে নাও। Well, the case is
original order passed by the
learned tribunal, which
what
was
happened?
not.
What is the dispute? What is the order
Well,
impugn?
may
There's a problem with the cost. It's a Didi. Oh, Didi.
Cost title.
Yes, yes.
Well,
Then with the cost title.
may I
what
place
is
the case, man? May I place the case, my lord?
No, no, there's a problem.
What? Demonstrate the problem, sir.
Kindly looks to it below the cost title. He has challenged the judgment of the building tribunal.
Yes.
The building tribunal was an appellate forum.
Yes. Against the 227 is not maintainable.
No, no, the trial court's thing is not there.
That procedure has been, I think, has been amended from your end, not in the appellate side rules.
Who has amended? Huh?
You yourself have. I'm recording your submission, Mr. Chatterjee. You have to
Absolutely.
take responsibility.
Yes, yes. Because this is a procedural form part, it needs to be followed. Simple as that.
Will apply equally to you also.
Absolutely. Apply it to everybody. Why just me? Everybody. But that's the law. That's what
Nowadays,
we've
that
learned.
practice is not being followed, Mr. Chatterjee. Even previously,
Don't give that
only the photocopy was being annexed. Nowadays,
Now,
that has also
that
not
also gone. You know, they should do it. And even the cost title needs to be amended.
No, I have produced.
What is the difference?
He's only challenged that part. Affirming there is nothing.
Mr. Chatterjee, for that you are there. You are not saying anything.
I will not move the matter. That was the first thing I learned. The first day, my lord, I entered it. Justice Bhaskar
All the seniors, I'm not talking about the designated senior advocates. If all the seniors tell this to the juniors,
I'll tell
I'm
him.
sure that this will not come. But you are not.
No, I don't think, my lord.
I'm not telling only to Mr. Aniruddha Chatterjee.
I'm
All of you, but you are not.
But they must learn as well.
Yes,
Learn as well.
it's after all you who have to make them learn.
See, the first thing I'll tell him right now. First thing, cannot be an appellate side because there is no appellate side in the original division jurisdiction in the original.
Right.
One. তারপর এইখানে লিখতে হয় affirming or reversing the এটা সেই that is the cost type.
ওটা cost title
Change করে নে।
So, my lord, may I?
On the prayer
back and hear the matter
Ah,
in that
It
case.
was refused on the last occasion, your lordship has seen
No,
that.
it was not
There was
refused, my
no-
lord. It was considering, my lord. Learned,
Yes,
the Honorable Justice,
refusal.
Honorable Justice
prayed for,
was
my lord said
hearing
prayed
it, my
for,
lord.
but
No, I did
refused.
not. There was no indication for the refusal. I was directed to produce the order, certified copy. That was there. My lord, there were two parts in the order. The first part was the retention. Second part was the demolition, my lord. Therefore, my lord, this demolition portion, my lord, this
It has
appeal
been
was
remanded. It has been remanded.
কি remand করেছে?
In the circumstances, we are not you are not inclined to remand the matters.
So, my lord,
Having interest of inclined to dispose of the appeal.
Basic premises, he doesn't have a sanction plan, raise the 5-storied building. With a sanction plan.
Without sanction plan, Mr. Chatterjee.
my lord, may I demonstrate the case?
With or without, please tell me this.
My lord, there was a demolition order which was already executed earlier. They have come to execute the earlier demolition order in the garb of issuing the new demolition order. That is my case, my lord.
But whether you have a plan
Yes,
for
my
this
lord.
structure.
We have the plan. We have the plan, my lord. In the order, there was the direction for regularization upon payment of the retention charge. And I paid that charge.
What will happen? What are you?
27th, my lord, they have
27th
of this month, they have given a notice. They will come to demolition.
Even on
That's
the
the
last
only thing.
occasion, they said, my lord, on the day that the matter was heard, they said that tomorrow is the day when they will
On the
come and
day
demolish.
they brought the
And
bulldozer
the
and all.
corporation doesn't demolish.
My lord, you understand the situation. It can happen at any point of the time, my lord.
Kindly have
My
a
lord,
look
if
at.
your lordship wants
Who is appearing for the corporation?
Mr.
Devjit
Mukherjee.
Mukherjee.
No, Mr. Mukherjee must be assisted by someone.
He was submitting.
You are the junior of Mr. Mukherjee. Where is Mr. Dipannita Ganguly? Where is she? Both have not come. Mr. Aniruddha Chatterjee, if it is demolished on 27th, what will be done?
No, my lord, there is no question of demolition at all. Even on the last occasion, my lord, he came up and said that tomorrow it will be demolished. Today, my lord, it's about a month from there.
Chatterjee, any notice has been served upon?
Yes, my lord. I have annexed the notice, my lord, with the mentioning slip yesterday. My lord, I am giving.
Please
that
give
note.
me a
Copy,
show me
my
the notice.
copy,
Please show it to
my
Mr. Chatterjee.
It's a corporation.
No. If there is a notice for demolition, Mr. Chatterjee,
Then here's it out, then here's it.
Mukherjee, the corporation is not here.
Then here's it, because without hearing no sanction plan, nothing.
I'm keeping it on another day.
Huh?
This construction was made long ago.
No, 2008 demolition order. They've been able to stay it for such a long time.
Since 2008 to 2026, it's continuing.
My lord, kindly hears it. If there is something, my lord, then your lordship would, but not just because there is a demolition order. Kindly hears it. কোনটা রিট যেটা আমার এক্সিকিউশন হচ্ছে না আচ্ছা এক সেকেন্ড
And there is another problem, my lord. They have filed one writ petition.
এটা কি গো সন্তোষ গড়াই
Officer?
কাকে দিয়েছে মোয়াজ আহমেদকে
আমার সন্তোষ বাবু।
Yes, 24th July. Keeps it tomorrow. Tomorrow. Huh. 24th is next Friday.
Before Ultorath, Mr. Chatterjee, demolition.
My lord?
Between Rath Jatra and Ultorath, demolition will be done.
Yes. Let it go.
No, lordship, if I read the order, lordship will
That's got
understand.
nothing to do, my lord, with Jagannath at all.
The corporation retained it, my lord. They were directed to retain.
All right, tomorrow.
They have taken the money. After taking the money, corporation is coming to demolish, my lord.
An accommodation.
Jeopardy, my lord. Whether a person can
That
be
happens. Double
Yes.
jeopardy. If you
If you want to bring it here.
Mr. Chatterjee, only one thing. if it's in violation of the municipal building rules, then it has.
But
to be.
moreover, my lord, there
The
was no
learned
cross
judge
appeal
has-
which was filed. My lord, by-
Otherwise,
The learned
there is
judge,
no use of these rules and the act.
learned
Also.
tribunal
what
has
happened, my
said
lord? They did
that
not file any cross appeal.
Then
my
nobody will take a plan. Nobody will do.
Lordship, the unauthorized portion has already been demolished by them.
no.
That is not their
It has
case,
been
my lord.
demolished. The corporation will be the best person.
Let them come
corporation
and see. my lord.
submit a report. It has been demolished. If it has been demolished, then nothing remains to
Yes,
be.
my lord, I have those things to show.
3 floors which are my lord illegal. Only the 5th floor was demolished. The other 2 floors are still there. I'm sorry, 3 to 4 floors are still there.
No. My lord,
Entire
everything.
building is without sanction plan.
No.
Completely.
No.
Then
No, I have a sanction plan.
no sanction plan for how many stories?
My lord, there were till 4th floor it is sanctioned. Only 1 floor there was. I will show. There only 1 floor which was
With the sanction plan.
sanction plan, the original.
All right, do one thing. Please show it to Mr. Chatterjee. That's sanction.
Come back tomorrow. Give me a copy.
Tomorrow I'm keeping it. Yes.
Well, this is the sanction plan.
Please show it to Mr. Chatterjee first. Yes, where is your specs, Mr. Chatterjee?
যাচ্ছি আমি।
Don't need now.
I can't at all. Nowadays it's absolutely gone.
বাংলা মতে G+3 স্ট্রাকচার
বাংলা মতে?
বাংলা মতে
কোথায় লিখেছিস? এটা বাংলা মত?
G+3
না বাংলা মতটা কোথায় লিখেছিস?
না G+3
So G+3 is 4 stories.
4 stories. I meant that, my lord.
স্যাংশনটা কোথায়?
Retention charge.
There is no sanction plan. This is a
My lord, sanction was there. They have accepted a retention charge.
Where is the sanction plan? What is that?
This is the plan.
বিল্ডিং ডিপার্টমেন্ট বড়
এটা কি?
বিল্ডিং ডিপার্টমেন্ট কার?
জজ সাহেবকে দেখো, আমি বুঝি না। আমি এসব বুঝি না। নেভার সিন আ স্যাংশন প্ল্যান। দেখি এটা যদি স্যাংশন প্ল্যান হবে।
You have never seen a sanction plan.
Lord, I could not construct even a brick, unlike.
Whatever I have,
because everything you got ready-made.
But that's the worst part. Getting it ready-made and keeping it is the worst part. The sanction planই নয়, ও যেটা নিজের বাড়ির জন্য বানিয়েছে সেটা নিয়ে
ওখানে স্ট্যাম্প মেরে দিয়েছি,
স্ট্যাম্প মেরে দিয়ে চলে স্যাংশন হয়ে গেল। এই আর কি
Plan, Mr. Chatterjee. This is a structural plan.
This plan I had, and I on the basis of that everything was
cannot be.
জানি না বলে আমাকে
Cannot be.
No.
This is only the structural plan.
Well, kindly see.
All right, come back.
They have taken the retention on the basis of this.
Retention?
Once you say retention, that means it's unauthorized.
No, that portion. They have accepted retention charge on the basis.
All right, but it's only a structural plan. Not the sanction plan. There are many stages, Mr. Chatterjee.
If I just distinguish
just
between
because
the
I don't
structural
know
plan and
the-
the sanction plan, my lord,
I have never
there
seen
can
a
be
sanction
because-
plan. Mr. Chatterjee is taking me for a ride.
Yes, call the next matter.
my lord, this is also part of the certificate. Their submission also say that.
Yes.
They are admitted.
26, yes.
26 সময় নিবি?
My lord, I am appearing on the item number 26, led by Lavanyasri Sinha, my lord. Kindly allow her online. She is
Led by
Lavanyasri Sinha.
Yes, yes. What is this matter?
Lordship, item 26, I am appearing for the petitioner. Lordship, I am only seeking expeditious disposal of my Order 39 Rule 4 application.
Order 39 Rule 4?
Yes, my lord. The
It's ready
plaintiff,
for
my lord,
hearing.
filed.
What is the date fixed for hearing? What is the next date fixed for
Lordship,
hearing of that?
I had filed my application in the month of May. Now, Lordship, kindly sees the impugned order 16th May.
This application under
Much of it.
Lord, as it fell from my lord, Lord, my instruction is, Lord, whatever the situation is, Lord, let it continue till till my lord returns. Lord, fix this matter on 4th of August. Lord, we shall
You're
make
not agreeable
submission.
to go to Mr. Chatterjee's house.
Lord, my client's instruction is all the same. Lord, lawyer's chambers only. It's Lord, his.
Don't see any.
No, that Lord, I have tried to impress upon Lord, but at the end of the day, Lord, takes it upon 4th of August, Lord. We shall make submission of merits.
Let the matter retain its position.
My lord will be returning.
না তো যাচ্ছে তো পরে
তাই তো বলছি, Lord, keeps it returnable on 4th of August. Lord, kindly keeps it returnable on 4th of August.
1st of August.
4th of August, Lord. 1st of August.
If not on 1st of August, then on 4th of August. Please try your luck
Lord,
first on 1st
Lord,
of August.
kindly keeps it on 4th because there is a monthly list. But I'm afraid of that.
If first come on 1st, then I will consider.
Kindly, Lord, keeps it
So
on
both of
4th
you
of
can
August.
argue at your heart's
No,
Yes, call the next
Mr.
matter. Call
Chatterjee
the next
won't be
matter.
there.
Chatterjee will be there.
Lord, Lord, kindly, Lord,
No,
keeps it on
Lord,
4th
I
of
have
August.
fixed the matter on 1st of August.
Yes.
Lord, keeps it on 4th of August.
Justice Chaudhary.
That's a working day, Mr. Kormakar.
Yes. He doesn't want to come.
Please work on working days.
Yes.
Don't
Lord,
remain in the chambers on that date.
We are more busy in the chambers than in court. Anyways.
Yes, yes.
My lord, I'm for the petitioner, my lord.
Yes.
I'm for the opposite party number 2 and 3.
Yes, Mr. Banerjee, what do you say?
My lord, there was a Supreme Court order in which the SLP was not admitted, filed by the tenant, my lord, lost in all the courts. My lord, in the Supreme Court, they gave an undertaking that they would vacate the property within 6 months. My lord, the council's undertaking, still thereafter, they did not give the written undertaking before the Supreme Court. My lord will find the order.
What is the MC case? What is the MC case?
My lord,
Miscellaneous
MC case filed by
police
them.
help, police help.
For
My lord,
police
kindly-
help.
police
So I'm
help.
directing that to be disposed of.
My
My
lord,
lord, kindly see.
my lord,
My lord, kindly permits me to make my submissions for a moment.
Yes.
Lordship was pleased on the earlier occasion, my lord, to look at the Supreme Court's order and issue notice upon the opposite party, my lord. Lordship will kindly see page number 35, but the relevant portion is at page 36, paragraphs 3 and 4. This was the only reason, my lord, Lordship has issued notice to the other side, my lord. My lord, and thereafter series of recalls, my lord, adjournments, dates even taken for issuing a notice to the court
Yes.
building.
What do you say?
my lord, the first thing is this. They have
After
filed.
giving an undertaking before the
my lord,
Supreme Court,
kindly consider. Kindly
you
consider.
don't want to abide by that undertaking. I'm asking you. After giving an undertaking before the Supreme Court, you don't want to abide by that undertaking.
My lord, I would.
I'm
But
keeping it tomorrow. Please take instructions and come back.
my lord, they have challenged 3 orders.
Please take instructions, then make submissions. Tomorrow I'm keeping, not today.
Grateful.
Yes, next.
Great.
Yes.
Marat, the last occasion, Marat, I prayed for time so that I can talk to my client. I tried utmost, but my client want to proceed with even after knowing the fate of whatever the stage of the proceeding. Now I want time till 2 p.m. so that I can make ready to challenge the quantum of the occupational charges till 2 p.m.
No, no, you have challenged that.
I have challenged that I have to gather some document till 2 p.m. today, so that I can substantiate that the awarded amount is exorbitant in that locality.
I'm vacating the order. Entirety. Cannot be piecemeal. I accept that, I'm vacating that. There will be no stay, no condition.
Jeez.
Sir, your client is standing behind you. Please ask her not to stand by that. Yes.
Now, 3 points which I have challenged in the order. Since the quantum is exorbitant, which I want to rely upon some documents, so that
Did you place those documents before the appellate court? You have not placed. How can I look those for the first time here? If you want to place those documents, you have to go back to the appellate court. Do that before the appellate court.
Anyway, adjourn till 2 p.m. I'll come back and
2 p.m. Yes, next.
And for the opposite party, number 1.
Yes.
Lord, on the last occasion, your lordship, my lord, directed me to furnish, my lord, the entire set of certified copies.
Oh, that one page was missing. Yes.
Lord, I have applied, my lord, in 1 day, my lord, they could not give.
Oh, applied. Where is that?
Yes, my lord, this is.
I'm not on that.
My lord, I have that 1 page, my lord. If my learned senior friend does not dispute the same, my lord, your lordship
No,
can
I'm not
rely.
disputing that. He's appearing.
All right. Yes. Mr. Mukherjee, do you have the entire copy of that order? This order sheet.
No, order sheet, my lord, I don't have the entire.
Oh, this impugned order.
Impugned order, yes.
26th of March, because this is not a complete copy of the order. 26th of March, 7th of November, and no, 7th of November, complete copy is there.
Only
26th of March. Can
26th
any one
of
of you give a complete copy of 26th of March?
6 মার্চটা আপনার কাছে ছিল।
Yes, yes. What is this matter?
This is, my lord, this Xerox copy.
You are giving the entire copy. How you will argue?
Lord, there is a set, my lord.
You have a set. All right.
Yes, but I have a 26th March, my lord, entire copy.
26, you have a copy?
26th March 2019.
এটা দিয়ে দিন তো। Yes. This is a typed copy of a photocopy of
No,
that.
but it's an internet plot from
yes.
website plot I have downloaded.
Yes, yes, Mr. Mondal.
Yes. Lord, my application for reconsideration has been kept pending, my lord. My application is at page 33. It's, my lord, I have prayed, my lord, for reconsideration of the order dated 26th of March 2019, whereby, my lord, my show cause application for acceptance of written statement has been rejected and the suit has been fixed for ex parte.
26th of March
2019, my lord.
Yes, written statement was not accepted.
Yes, my lord.
Then you have filed the recalling application when?
In 2026.
2026. Lord, only one thing, my lord.
On the date?
On the
suit
date
was fixed for ex parte argument.
No, my lord, on that date I was present. On 26th
No,
of
on
March.
which date you have filed this application for reconsideration? When it was fixed for ex parte argument?
No, my lord, for evidence. PW.
For PW.
At present, my
Yes,
lord.
so if it is without written statement, what remains? PW will give his evidence, we will cross-examine. That's the only limited scope.
My lord, only one thing, my lord. Court has extended the time. My lord, within the extended time, my lord, I have filed my written statement and it was, kindly, my lord, seize this order, my lord, 28th of November 2018, my lord.
28th of?
November 2018. Kindly, my lord, seize, I have filed my written statement along with the application for show cause. I kindly, my lord, see the previous page, my lord. On 29th of June 2018, I appeared I prayed for extension, my lord, to file the written statement. On 31st of July, my lord, that I again prayed for time to file written statement, and thereafter
You are defendant number 2 and 3.
2 and 3, my lord. Seventh September it was extended, and thereafter I filed on 28th of November 2018.
Where is your application for acceptance which you filed?
26, my lord.
Page 26.
Page 26.
26. What is the suit for?
Trespasser eviction.
2G. 2G. Yes, Mr. Mukherjee, what do you say? If the written statement was filed on a date fixed by the learned trial judge, and that extension not being challenged.
Similar, I am on the conduct. 2019.
Mr. Mukherjee, the court has extended it. Maybe you may be justified in arguing that no, without reasons, it could not have been extended. But that order has not been challenged. An order has been complied with. So, party
statutory period of
penalized
limitation
for complying with the court's order.
The statutory period of limitation is there. He is conscious. He filed an application.
Extension is also permissible.
Yes, my lord.
So this
He filed an application
allowing a time after the statutory period, does it not amount to extension?
No, my lord.
Which is
Why?
permissible, but subject to.
Why, my lord? He filed written statement, thereafter filed an application. He has not taken aid of that, my lord, the earlier order. He filed an application for
surpluses.
Yes, my lord. He has filed an application.
Not necessary after it was extended.
Three-paragraph application he has filed, and that has been considered and rejected in 2019.
Was there any necessity?
But I'm coming. In 2019, that has been rejected. Thereafter, the suit got ex parte against both these defendants. He filed an ex parte vacating application that was rejected in 2024. That's the second order challenge before your lordship. I am showing just the conduct. When the suit ripened up at the hearing stage, when my evidence has been filed, then to wriggle out of this, in 2026, this is the third attempt. Kindly takes up the order dated 7th November 2024, impugned before your lordship. I believe that is annexed.
Yes.
Kindly see, the conduct is being recorded by the learned trial judge, even on this order in 2024.
Yes. Then,
my lord, 2024, he did not challenge this order, kept quiet. Thereafter, my lord, the impugned application for recalling in 2026. After, my lord, my evidence is being tendered. And the present revisional application, my lord, your lordship is well aware. Lord, there is no prescribed period of limitation. But still, the 2019 order is being challenged, only paragraph 15, whether this is suffice, my lord. Sitting under Article 227, your lordship has to, my lord, also balance the equity.
I will remember this argument when we will be appearing in this site. Now there is no problem. Everything is on live streaming, so it can be found out.
After 8 years, only paragraph 15.
That is what I am telling you. That
এই তারিখে আমরা ফাইল করছি।
Yes, Mr. Mondal, what is your occupation? Not the deponent's occupation. Blank.
Business.
Mr. Gayan has not filled up.
No, no, no.
Please take this copy. দেখান তো। No, he has not been favored. His clerk has not favored him with those. Please look at the deponent. No.
See.
Affidavit portion.
Chartered account.
What is the occupation?
Chartered account.
So after that, you are saying paragraph 5. 15. Chartered accountant is the layman.
With regard to the laws of the land, my lord.
They are not aware. They were not aware. What are you saying?
My lord, only one thing kindly, my lord, seize the last order, my lord, 19th of June.
Mondal, after looking at, now I am thinking of the quantum, which is to be imposed now.
Lord, only one thing, my lord, 19th
False
of
statement on oath. False statement on oath. At least your client must be aware of the consequences of that. Being a chartered accountant. Yes. What do you want?
19th of June, my lord, kindly seize the order. My recalling.
19th of June.
Yes, 19th of June or 19th of June 2026, my lord.
Oh, the impugned order.
The impugned order.
Last order.
Last order, my lord.
Yes.
Last order, my lord, kindly, my lord, seize my application has been kept pending. And my lord, the next date has been fixed on 9th of July 2026 for show cause.
Mr. Mondal to take instruction whether he wants that this reconsideration application should be heard on merits before the trial court. Then he has to, my lord, withdraw. That's instruction for this, my lord, your lordship.
Other challenge to the other orders, you have to withdraw from here.
I have instructions to withdraw from the other orders, my lord, that which is under reconsideration application. But I have instructions to withdraw that. Let the trial court, my lord, decide that application.
After some argument. Who has given this? You have given this. Take it back. এইটাকে রেখে দেবেন মিস্টার মুখার্জি আই এম কিপিং ইট এইটাকে রেখে দেবেন একটু লাগিয়ে রেখে দিন জাস্ট কল দ্য নেক্সট ম্যাটার one yes who is for the Other side.
Yes.
Uh,
It's it
yes.
after your lordship returns and my lord will give.
I'm keeping it on
Item number? Lordship is returning on my lord 31st, I think.
I'm keeping it on 4th.
Fourth.
Only one thing, my lord, I've taken instructions in this matter, and on merits we are opposing, my lord. Now
I'm keeping
Supreme
it
Court
on
has
4th.
also.
I will hear it on.
No, my lord.
Wait,
My lord,
this is a writ
first of
petition.
no, my lord.
No shortcuts.
Because if it goes back to the trial court again,
It has no, you cannot say all this.
No, I can say.
He cannot say all these things.
No,
If
no,
it goes back to the trial court, it will take time. Those are.
He can press his.
This is not a writ
Revision, my
petition.
lord, I will give my
For
reply.
paucity of time. Nah. This matter was
Please to hold that these order 22 application.
you have checked up, Mr. Ghosh.
So, my lord, what happened? My lord, two applications were filed. My lord, one is amendment application read with order 22 rule 10. I was agreed with order 22 rule 10. Therefore, my lord, this is applicable order. What I was humbly praying, my lord, you also kindly make the certified copy. In the meantime, I shall file an appeal. Pleading for the petitioner, my lord, opposite. Page 2A.
order my section 47 was not allowed. On the ground, my lord, this principle is, my lord.
But I just indicate one thing, my lord, then minute I'll take my seat. My lord, by the impugned order, two separate applications have been disposed of. A single civil divisional application. And if my lord, my lord,
No, if both are within the point of
one is my lord 47, one is
no,
my
no,
lord
is
20
within a reasonable time.
on the same
Though
day.
there is 227, there is no limitation.
On the same day, on the
same
day,
day.
by the same order, two separate applications. have
One
been
is
given.
their maintainability, one is my
What is
47.
the
It's the same
difficulty,
thing.
Mr. Banerjee?
My lords have taught us that, my lord, if there are two applications,
No, my 47 has gone. I am on that. My main application has gone. So
and
therefore,
I
I will have
remember to have lost one matter, my lord, before your lordship on this point.
On that point?
Yes, that were two applications, one single order. My lord, if two different orders in one matter, one civil division
But I don't think that.
yes.
Yes, but here
Here, my lord, two different applications by a single order.
no, two different applications mean two miscellaneous cases.
One is below section 47, one is below maintainability of section 47.
That's the same
Same thing.
same thing.
Same thing.
But Mr. Shane, how much time will you take?
Mr. Sen,
But I don't usually get
But only thing is that from in 2 p.m. there is one original side matter, though it may not take much time because it's a
we can
election.
keep a watch, my lord. We can come also, my lord.
In case, my lord, the matter is not taken up, my lord will kindly indicate, my lord, that my lord, pendency of this revisional
No,
application.
then I will have to press, my lord. It cannot be like
I
that.
got an award. My lord,
No, you have,
may I?
have got an award. I have got a suit.
Years back.
I have got
34, 37, Supreme
well,
Court.
very well.
Award is upheld. My lord, in execution, now the award debtor comes and says that, my lord, the
My application, my lord, I must get that privilege of addressing you,
I hardly get such a good matter, so my lord, can't resist my temptation. My lord, I was thinking of the quantum of the cost, my lord, which should be imposed.
Well, let us see, my lord.
After 2 p.m.
After 2 p.m.
After that matter, it might not take much time. ঠিক আছে দেখি ডাকুন একটা ছোট ম্যাটার যদি থাকে
Grateful.
32 is appearing. এটা কিন্তু 2 p.m. এ আর কিছু নেই তো ফিক্স 2 p.m. এ কোনটা আছে একটা 28
We must get a chance today, my lord. I think my learned friend is so much vigilant that I must open my case.
29
Open and shut case, my lord.
all right 29 there is also 2 p.m. It might not take much time, so after 29 I will be taking
Wait for
after the original side, then 29, then you আর কিছু 2 p.m. নেই তো hopefully we'll be getting a chance.
I also need a chance, my lord, to shut.
Yes, who is appearing?
My lord, 32, I am my application, my lord. This arises from a order which has been passed up, indicating that the stay which was granted by an order dated 8th May 2026, I have not complied with the conditions. My lord, the matter before
said that check was for
my lord, not check, demand draft. Demand draft of
says the entire amount
But the entire amount was not paid within the time, my lord. My lord, so far as page 143, my lord, there is a default for 1 month, my lord. A substantial
compliance has been
with
made.
that, my lord will direct, my lord, on 18th of August, my lord, the matter is fixed for appeal hearing, my lord.
Appeal hearing.
Appeal hearing.
Appeal is ready.
Appeal is ready, my lord. Let it be taken up for hearing and disposed of before Puja vacation, my lord.
Where is the amount?
Amount already deposited by court deposit on 25th. All my
The draft is lying in the court.
My lord, draft is lying with the court. Court deposit also made for the same amount. Also deposited
court
in
deposit
court.
also
Yes,
made.
both done. I have paid double the amount, my lord. Now it has to be restituted. And only issue was, my lord, I ought to have paid
No,
within.
the only thing is that draft, the validity period is there.
Yes, my lord. It was 21st May. So till August it is valid. And
till August is coming.
My lord, 21st August it is valid. All together, my lord, I have already paid that amount.
One thing, because not Mr. That Sen, Mr. Saurabh Sen, because otherwise that check will become invalid. Then it will be a difficult thing.
But
He
so
has,
far,
he has paid double the amount.
Double the amount, my
So
lord.
he has deposited in court and the draft is also there.
Yes, my lord.
You accept that without prejudice, that can be adjusted with the future occupation charges.
but so far as the draft, my lord, they have deposited in the court, my lord.
Yes, my lord.
You can take
Take
back
it.
that
My lord.
from the court. I give you liberty to take
My
back
lord.
subject that will be adjusted against the future occupation charge.
Well, it will be 6 months now that I have paid. I have paid for 6 months. I've already paid in court deposit. For 6 months, draft is also kept with court. So for the next 6 months, they can take that. I have no problem. Till June, it comes to an end. Till December, it is
Even
paid.
if the appeal is disposed of prior
Even if
to
the
that.
appeal is disposed of. Well, let them take it. I have no
But
problem.
my instruction is to oppose, my lord. But
My lord,
my lord, one
I
day
can show judgments, my lord, that it will relate back to
Please
the
come in a
original
better
date.
case to
my
oppose.
lord, my lord.
Not in
No,
this
no,
case.
my lord. In case I appear for the tenant, my lord,
This application under Article 2 Otherwise, if it lapses, the entire order is to be then modified. Yes.
My next submitting both of us there, Malad, instead of waiting in the afternoon, if we can come back tomorrow, Malad.
I do not have any difficulty accepting that, Malad. My Leonard Junior would not be there in the second half tomorrow.
Only thing is that Mr. Sen, tomorrow will be the last day. That's the only difficulty.
Oh, your lordship is not there.
That's the only
It gets
difficulty
spilled over
because
then.
if it spills over or
Very well, we shall take our chance. Otherwise, kindly, if in case it is not
or
taken,
if both of you agree, I can keep it after.
they will not agree. This is the difficulty.
Malad, this pendency of the revision and application is being shown to the learned trial court.
Only Mr.
One-liner from your lordship. A one-liner from your lordship today, that Malad pendency would not be.
Then my application is not. This is not fair, Malad. Your lordship.
Let us come back.
Hearing, Malad.
Malad, this is being dangled. My learned senior friend is not there. Malad, this is being shown.
No, no, of course it is being shown. I am not shying away from that. If I have
the
final
only thing,
division,
then I can, or I can do one thing. I can keep it on 1st of August. Both of you can argue.
Malad, next Tuesday is the date, Malad, before the learned trial
If
court.
you can agree to that on next Tuesday.
Malad, I'll be beheaded by my client, Malad, if I agree.
Next item,
Malad, item number 33.
Changing the appeal number, Malad.
Oh, there are two matters.
Two matters, Malad.
That is also same. 6
Identical.
months.
Yes,
Appeal
yes.
number different.
Only appeal number is 85 and 86. First one is 86.
সুটের নাম্বারটাও বোধহয় চেঞ্জ হবে, ডিগ্রির ডেটটাও একটু
4. When I come back at 4 to conclude my reply. Lordship. Said that yesterday to remind your Lordship. 54.
Tentatively at 3:30.
3:30.
Tentatively,
Better.
if the other matters are
Better.
concluded, then.
3:30 here. Other side is here. I mentioned.
Great.
May your lordship permit me to mention
Yes.
one matter, since 2025, it has been mentioned before your lordship, but it has not come as yet for upgradation, my lord. Kindly
please.
consider to some extent, otherwise the application will be infructuous and the city court has fixed for hearing.
For the sleep.
Lordship, may I to permit to mention one very urgent matter. Item number 196 of the combined monthly list. This is expeditious disposal.
Expeditious disposal is not an urgent matter. Yes, call the list.
My lordship, may I be permitted to mention one matter?
Please, this is not the bedside time. Please come tomorrow.
I beg to appear for the petitioner, my lord.
Yes.
This is coming up for the first time, my lord.
Yes.
My lord must be having an office note from the superintendent, my lord.
Yes.
That must show that is there any defect or not, my lord. If there is any defect, and I'm also carrying the election petition rules. If my lord is satisfied that there is no defect, then my lord can grant an order directing issue of notice under Rule 24, my lord. This is the election petition rule of our honorable court.
Yes.
I'm also carrying a similar order.
So any defects have been notified?
My lord, nothing to the petitioner, my lord. There must be an office note in the my lord's brief. Kindly see Rule 24 of the rule that I handed over to your lordship.
Rule
24, my lord, internal page 10.
Yes.
But if my lord is satisfied that this petition will not be dismissed under subsection 1 of section 86, then my lord can direct issue of notice to the defendants, my lord. I am also carrying a similar order passed in a similar matter, my lord. I'm just praying for only one indulgence that my lord may pass and if my lord can pass in direction that pending this suit, my lord, all documents, case record, election paper,
Yes.
and devices be.
Where are those stored? Or booth numbers, anything there?
Well, I'm actually challenging the election of the constituency, my lord. Of the
No,
House
I
constituency.
follow that, but have you specified
My lord,
anything where those materials were stored now, where they are lying? No, that you have not stated.
That I have not stated. Well, I shall be candid to your lordship. That I have not stated, my lord. Well, but in order to protect the lease, my lord, those things required to be, my lord, protected.
Yes. Yes.
As regards the present market trend of that area is much lower. And as because I searched out, it is true that before the appellate court, that document or that kind of material has not been placed. But
How
it is
can I look into that for the first time here?
one thing can be done. One thing can be done. Direct the court below to rehear the matter, maybe upon depositing some amount on account, because it is true that it is much higher, it is awarded. Not
it is true. That is your submission.
No,
They will be
no.
saying it's lower.
Why I am saying in that same court there are so many matters relating to the same area.
While staying in this property, you can search out a better accommodation at a lesser rent. It's better.
My lord, the valuation of the property,
the condition is not very good.
The value
It may collapse at any point of time. Please vacate, search a better accommodation with a better facilities at a lower rent. Maybe in a better locality.
Lower court record is available with the appeal court. Only one hearing is required. I know everything, my lord. Still, I cannot pressurize my client. Now, what is I am trying to submit, my lord? Since the order has been passed by the court below, awarding 8,000 rupees per month.
8,000.
8,000 rupees per month. And here, my lord, it is the I have gathered from the e-commerce site. It is for 100 square feet to 200 square feet. 5,000 rupees per month is a normal rent in that locality, and the shop room is only 30 square feet. Now,
what do you say?
The property is on road, main road, station road, Hindmotor station road. Now, my lord, he has
You want to fight out on the occupation charges, or you want the appeal to be disposed of?
I want appeal to be disposed of.
Yes,
And my lord, despite direction of the landed appeal court below, they have not till deposited the occupational charge as of now, my lord.
As steps to be taken before the court. Now, my lord, the second point which I am raising, the date of implementation of the occupational charges in the impugned order, that is from the date of filing of the appeal or from the date of the impugned order before the appeal court. Although the fact remains, particularly in this case, when the miscellaneous appeal was filed for the first time, the court granted an order of stay, ex parte ad interim stay.
Why miscellaneous appeal?
Against the order granting police help under Order 20 and Rule 97 CPC. My lord, then after obtaining the ad interim order of stay, the opposite party appeared in the miscellaneous appeal court. Instead of taking any steps to put on term, they have preferred one application raising point of maintainability, and they have said that since it is not come under the Order 43, the appeal should be dismissed, and accordingly the court first dismissed the miscellaneous appeal. I have come before this court. But in the meantime, according to the view taken by the court below while dismissing the miscellaneous appeal, I also filed one title appeal where an application for Section 5 and stay was also filed, where an order was there for 10,000 rupees occupational charge. But since after that one order has been passed by this court, a coordinate bench of this, if you also kindly turn to the relevant page, at page 57 once. The order is at P53, starting from 53, and 11 pages 57.
Yes.
I am reading out the paragraph 17 onwards.
Yes.
Mr. Banerjee, learned advocate appearing for the opposite party, submits that petitioner should be put on terms for enjoying the stay order. Since stay was there, it is the first time the opposite party raised that point that I should be put on terms.
Yes.
It will be open to the opposite party to make appropriate application before the appellate court, either the operation of the order of stay by dint of this order or at any time thereafter for imposing appropriate conditions for continuation of such stay, and that has been granted only for a month, since this honorable court has limited the order of stay for only 1 month, and in the meantime liberty was granted to invoke that. And accordingly, in the next paragraph, in case any such application is made, the learned appellate court is requested to dispose of the same as expeditiously as possible and preferably within a fortnight from the date of filing thereof, after giving an opportunity of controverting the same to the petitioner. The learned appellate court is also requested to dispose of the misappeal expeditiously without granting unnecessary adjournment to the either of the parties. And then, my lord, since I have taken undertaking to withdraw the title appeal, since the title appeal was not maintainable, that paragraph was there. But only thing what I am submitting, my lord, according to that liberty, to invoke that liberty, they have filed the application for occupational charges in the miscellaneous appeal court on 19th of May. But in the impugned order, while granting the occupational charges, the court granted the occupational charges since February 2025. That part, my lord, is I am challenging only because since the learned court, while granting stay in the miscellaneous court, when the appeal was revived, the stay order was also revived. Now, while the granting of stay at initial stage, court didn't grant any occupational charges at its own. Now, on the application of the opposite party, the date of the application should be implementation date.
Yes.
Filing the occupational charge. If the order, for the sake of argument, is affirmed, then on the other way, it is to be observed that the court is recalling or modifying its own order. That is, I think, subject to correction, my lord. Now, since particularly on the merit of this case, on the date of filing of the occupational charges application will be the date of implementation of the occupational charge. And the third thing is that your lordship kindly look at the impugned order. Apart from occupational charges, contractual liens are also directed to be paid. Contractual liens cease from the date of degree.
Where is that?
In respect of the property, last page, my lord.
4 lines.
The highlighted portion, the bold portion, with respect to the suit property by the appellant from the date of impugned order, that is from 18th February 2025, until the disposal of the appeal, the said occupational charges should be in addition to the monthly rent being paid by the appellant to the respondent.
No, that cannot be.
That 3 points I am arguing before your lordship.
What was the monthly rent?
That is much lower, 200, 300, like. I am not
monthly
on that.
Rent, occupation charges and monthly rent both cannot
cannot run concurrently.
Yes. Yes.
That
What do you
3
say to
points I
this?
got.
That it should be from the date of the filing of your application.
Filing of the miscellaneous appeal, from the date of filing of the miscellaneous appeal. That miscellaneous appeal was subsequently, my lord, dismissed as not maintainable. Dismissed as not maintainable on my prayer. On the first date, my lord, I preferred that application before the learned court below. That was dismissed as not maintainable. They preferred an application. That order was set aside. The miscellaneous appeal was restored to its own file. Now, my lord, from the date of filing,
when it was restored,
it was restored by virtue of this.
That order.
What is the date?
Page 53 was the order by this honorable court by which the matter was restored.
Page 53.
2nd of April 2026.
2nd of April 2026. Yes.
That is the order passed by this honorable court. That is the date.
Yes. So it was restored on that date.
On after that date, on the basis of that order.
Yes.
2nd of April.
By this order, it was restored.
By 2nd of April, this honorable court set aside the order dismissing the miscellaneous
appeal. That means it stood restored by that order.
On that.
Yes. So on that date, it stood restored. Then your submission is that thereafter an order of stay was passed without any condition.
Prior to that, order of stay was there.
No, my lord.
Without condition. Now that this court limited the stay for 1 month, and when they have raised that issue that I should be put on terms,
Yes.
liberty was granted.
Yes. What is
When the miscellaneous appeal was filed, an ex parte order on the first hearing, order of stay, unconditional stay was passed. Subsequently, notice was issued. I appeared and took out that maintainability point.
unconditional stay was ex parte.
Ex parte on the first date of hearing.
Yes.
Now, when the matter was restored, by virtue of this order of the court, I was granted liberty to pay for occupational charges since I have not paid in the miscellaneous appeal at the initial stage. Now, my lord, since the application was preferred, my lord, on the day of filing of the miscellaneous appeal, that was effected.
Yes. And what do you say to the occupation charges?
Occupational charges, my lord, so far as my lord, my instruction is concerned, my lord, in the local area, there is 10,000.
Any materials you have produced before the learned trial judge for the purpose of assessing the occupation charges?
Occupational charges.
Here, one thing I would like to mention from their
Let him complete.
No, that has not been produced. But what it kindly sees, the property is on a station road and is in is a very vast area. Not only that, may I, my lord, indicate, my lord, one thing, my lord. They have already purchased similar shop room opposite the scheduled shop room. They have their alternative, my lord, shop room.
I have no such instruction that they have
That instruction you will not be having.
No, I have
That instruction you will not be having. I know that.
I have specifically advised that to
I know
such
that
a
you will not
content.
be having that instruction.
No,
Because
then-
they will be having that instruction, you will not be having that instruction.
Whatever. I don't know whether it is true or false. So whatever, I'm not on.
Yes. Where is your objection to the occupation charges?
Before I turn to my objection, my lord, I would like to show you lots of
your objection first, then you will.
Very my objection is at page 65.
Yes.
It's page 65, and my denial is paragraph 9 at page 67. It is admitted that the shop room was measuring 30 square feet, having old and aged building, not situated on the main road, and the nature of the business from the shop room is selling tailoring materials, retailers.
Yes.
Now, what I'd like to show you, Lordship, the court below, while considering the matter while arguing, if you also kindly turn to their application at page 60 and the relevant page is 62. You also got it 62. It is their application for occupational charges where in paragraph 8 they have mentioned that in the locality approximately 15,000 per month is the market rate, but without without any basis, because on
You have also not given any basis.
We also, but in the prior portion they have it shows that
You have also
no,
not
that
produced
is
any
not
basis.
before the code below there is
When
nothing.
you have not produced any basis, you are accepting that. Otherwise, you ought to have produced some basis.
One thing can be done.
This presupposes that it is high. That is why you have not produced.
That is not the thing. That thing, the inquiry should have been done on better way on my part, on my client's part also. Whatever has been done before the court below, but since it is in the market value of which I obtained from the e-commerce side, since it was not available to the court below, your lordship can specify a time period to reconsider the matter.
Again,
to specify the period, even with deposit some amount.
Thank you. This application under Article 220.
But I am appealing for the petitioner. Lord. But this is in respect of a property which originally belongs to Kolkata Port Trust. Now, there was a sale of a company in liquidation was the original lessee under Kolkata Port Trust. Property of the company in liquidation was taken over, purchased by my learned friend's client. So they became entitled to the assets, but the matter went to the Supreme Court. Supreme Court said, my lord, if they will pay the entire lease rentals payable by the erstwhile company in liquidation, and an amount was also fixed,
They will be having the leasehold right.
They will get a leasehold right. So,
For
and
the
that there
residual
was,
period.
and there was a
For the
time,
residual period.
and there was a time period within which they will have to make payment of the arrears and everything. On this representation that they are the lessee, they entered into an agreement for license with my client. That is the agreement which is the subject matter of consideration now. That agreement had an arbitration clause.
Only one thing, Mr. Sen.
Yes.
You are appearing. May not be taken up today because Mr. Sen will like.
I won't take till 4:15.
No, 3:30.
There's a
Another matter has been fixed.
3:30
3:30 or 4.
3:30.
Which item? 53. Will be a contested one or the any arrangement? Because if it is a contested, Mr.
Mr. Kaur says medium.
Then Mr. Kaur, if I post it in the month of August, any difficulty? Because if you say no with that understanding, it can be solved within a few minutes. It's one way.
I have a suggestion to give. If that is acceptable, then that's why I said medium. But if that suggestion is not acceptable, then can you give it?
So you give the suggestion to Mr. Bordon, he can consider and come back.
Can you keep it for tomorrow? If it's contested, then your lordship comes back and decide.
In that event, to be mentioned tomorrow. In that event, to be mentioned tomorrow.
আচ্ছা তাহলে এটা না 53টা কালকে টু বি মেনশন
I'm waiting from tomorrow, Mr. Banerjee.
37 Mr. Ghosh, is it that urgent?
Yes, it is very much. Some urgency I cannot be my property last I just
Oh,
order.
that matter, Mr. Ghosh, it might take some time. Because Mr. Mitso is also appearing. Joyanto Mitso.
I appear for a party, Mr. Banerjee. Mr. Mitso.
Maybe difficult tomorrow because I can post it in August. 2 weeks.
Sorry. It's a Friday, I try to cash. Tomorrow I try to cash shorter.
Not be short going by the names of the councils.
Sir,
Other thing which can be done is 1st of August.
Myself,
1st of August.
I can say about myself.
1st of August.
Sir, 8 minutes fighting. For me, Millard, 8 to 10 minutes fighting.
No, Mr. Ghosh, you may take for 8 to 10 minutes with the other councils are there. That is why. 1st of August, I can keep it. 1st of August, I can keep it.
1st August, some precedence I am saying.
1st August, রেখে দিন।
1st August শনিবার যদি খুলে রেখে দিন সেই জন্য
ওয়ার্কিং ডে এই 1st of August ওইটাকে রেখে দিন। Please do one thing, ask your respective advocates on records to communicate to the councils.
3rd August.
3rd of August is the monthly list day.
4th August.
Why 1st of August? You can argue that's 8-10 minutes all. So I think let it appear on 1st of August. Thereafter, I will consider.
If Lordship will, I'll give us biomedia if that can be. Gives it tomorrow.
All right. Tomorrow it will remain, no problem. Yes. Other matters will not release.
My lord, from the order implement, there is a contempt pending before the division bench, my lord. Now, there is an order of the division bench.
Come tomorrow.
My lord,
When the division bench will take up?
My lord, then 28th, my lord. There was
Tomorrow come, because it's in the midst.
My lord, if some precision
Because
will be
if
given
this
tomorrow.
continues, you may not get a chance. That is why, in order to relieve all of you on Ratha Jatra day, I am releasing that.
So, my lord, if that
If you want to stay, you can stay. That is why.
My lord, if my lord can fix tomorrow any. My lord.
It will remain in the list, not fixing. Yes, yes, Mr. Shen.
So, my lord,
Sorry for the. ওই ওইটা
uh,
আছে আর except ওই অন্যটা আছে
on this representation that they are the lessee, I entered into the property in terms of the agreement with him. And there was an arbitration clause there. He purported to terminate that arrangement. I referred the dispute to arbitration with a prayer that this agreement is vitiated by misrepresentation because I found out from Port Trust that there is no payment made. There is no lease which has.
According to you, they do not have the leasehold rights. Or they have not acquired the leasehold.
They did not have acquired to leasehold rights. So that was the first reference. Initially, award was made in my favor. The award was set aside up to the division bench, which was followed by another reference. So in the second reference, their claim was for my eviction and min profits because they again terminated the arrangement. And they filed an application for interim award and they got an award for eviction. But kindly note this, still at that point of time, there was no lease. This point, then what happened? Then, then on 23rd June 2015, a lease deed is executed by Port Trust in favor of my learned friend's client with effect from 2003.
Retrospective.
Retrospective effect from 2003. This lease deed we have challenged in a title suit where we have said that this is an outcome of fraud and collusion. This should be set aside and this should be declared null and void. It is contrary to the guidelines of the Port Trust and this has been the result of fraud. This suit is pending and that is a prior suit. Subsequent to filing of this suit,
prior suit means prior
to the interim award which they have got in the second reference for my eviction. Prior to that, this suit has been filed and this is the issue in that suit, whether the lease which has been subsequently granted with effect from 2003 is valid and binding, and or whether it is liable to be declared null and void. So this is an issue which was pending. The award comes. Now, 34, 37, all the award is sustained. I am not going to that aspect.
After that, if
now the question
37, then what will be the fate of the suit now, Mr. Singh?
Yes. Now the suit is not good. The award and the dispute is not.
But it touches upon the foundation of the award.
Now I am saying, my lord, the suit is there.
Maybe, but the
see this provision.
All right. So let us proceed now.
Yes.
What is the submission?
So my issue,
so according to you, a suit alleging fraud with regard to the execution of the lease deed by and between Mr. Banerjee's client and the Port Trust, which forms the basic foundation of the arbitral award, that's pending.
I will say, my lord, doesn't whether it forms the basis arbitral award, the basis is not
or he's right to evict you by way of an arbitration.
Yes, that is the point. Now, my lord, kindly see, this suit did not have any effect on the adjudication of our rights. our rights in the arbitral proceeding were only governed with a so-called agreement. On that basis, he has got a right of eviction. Upon mutual adjudication of the mutual rights concerning a particular agreement. Now, my lord, but while that adjudication was done, there was also a suit where I have challenged.
116 come in your way, Mr. Ban.
No, here, my lord, there is a difference, my lord. Here, my lord, what I am saying is 116 will not come here.
Because you are trying to challenge his title. Can you do so?
No,
in a way
that I did.
Now it's execution.
Now it's execution. I am not saying
also
that.
suit whether you can challenge his title.
Here, my lord, if I may put it.
116 we might stare at your face.
If I will kindly consider it from this point of view, what does the award declare? Award declare.
No, I'm not on an award. I'm on the suit.
Suit, I am not challenging his right. Suit, what I am saying is, there is a deed which is on record. Deed, I am saying this deed could not have been executed by court trust. He incidentally is the lessee under that deed. I am saying port trust and the other party has acted in collusion with one another, brought into existence this document. This document cannot exist. This is the issue in the suit.
It's a collusive document, thereby practicing fraud upon you. In effect, practicing fraud upon you.
Yes. And now kindly, if I kindly see execution proceeding. The execution proceeding is in relation to this award for eviction. If the execution proceeds in the face of a prior suit which is to adjudicate upon the right of port trust to execute a lease deed. Suppose, my lord, if the...
So that was your prayer for stay?
Yes. My prayer for stay is that...
According to you, your prayer for stay is...
If you give him possession, if you give him possession now, then what will happen
to my suit?
To the decree, if it is passed in the suit.
Yes, to your suit.
To
What
my
will
suit.
happen to your suit? So, according to you, if the decree is now executed, you are thrown out of possession. So nothing remains to be decided in the seat.
Number one, suppose, my lord, what my learned friends will now say is that I am not alone in possession. There are several others in possession. Fact remains that if the execution attains its logical conclusion, if this person will get possession.
Which, Mr. Banerjee?
Yes, this person will get possession. Now, kindly consider the pendency of the suit. If the suit is decreed, at the most, what happens? KOPT holds on to possession, becomes entitled to possession because KOPT is the owner, no one is disputing. What is in dispute in the suit is only the document of lease. So if KOPT's right to grant lease is annulled, at the most maximum, KOPT's right to continue in possession remains. So therefore, today possession will be with someone else. But KOPT could have got otherwise been entitled to possession through also the other persons who are there. And now what will happen? Another person will be put in possession. It will change further hands. Suit ultimately becomes redundant. So legislature has thought of this situation. And therefore, when this provision comes in, kindly see.
Please, Mr. Shen, please show me that portion of the impugned order which deals with this part, that the prior suit, this
has not practically, with the greatest of respect, dealt with this issue. This has.
Did you raise that, Mr. Shen?
Yes, that is my only point.
So please show me from the impugned order you have raised.
Yes, of course.
Not dealt with is the other thing. But please show me that you have raised this point. Impugned order is the second volume.
The first volume also it is there. Just after the cause title.
What is, please give me the date so that I can verify.
Order number 80 dated 5th of June.
Yes, yes, I've got that. In my copy, it's the second volume.
Yes.
Nowadays, it's very difficult to find out the certified, the impugned order.
Yes.
Sometimes it is in the first volume when it contains 6 volumes. Sometimes it is in the last volume.
Usually we are accustomed to having it at the last. But kindly see the first page itself.
Yes.
The last paragraph there. In the instant miss case.
Yes.
The award debtor preferred the application registered the IA number 5 under section 47 read with order 21 rule 29 seeking for stay of execution of the award firm that the same should await the outcome of the civil suit between the same parties concerning self-same property pending before this court being TS number such and such. IA number 6 was filed by award holder questioning the maintainability of IA number 5. So they have taken it together, my lord. Then all these are the factual aspects which have come. Ultimately, your lordship will come to page number 4 top.
4 top, yes.
Award debtor in IA number 5 upon resorting to section 47 review order 21 rule 29 raised point of inexecutability on the ground of civil all question. Then, my lord, in IA number 5, specific grounds and issues raised by the award debtor are as follows. Lease deed dated such and such executed by KOPT in favor of award holder has been challenged by award debtor in TSCOM 32 of since the said instrument cannot proceed. Lease deed is especially illegal, fraudulent, void and executed. DO's provision of section 34 of the Major Port Trust Act and police guidelines. Lease deed dated such and such was terminated by KOPT by the letter dated 30 and thus the award holder has no right. This is again something else, my lord. Then, so this is my main point.
How it has been dealt with.
Yes, I'm coming to the operative part. Kindly come to page 14. Therefore, kindly see from here, my lord, page 14. Therefore, while considering IA5, this court has to be restrained within the 4 corners as delineated Supreme Court in approving whether the award debtor's cause is. But actually, I think this is the point which
116 was also considered.
In this application, 116 cannot be the issue. I am not going into the merits of the award. Here in a 47, I cannot challenge. My lord, as rightly pointed out, my scope of 47 is very limited. I am now particularly coming under order 21, rule 29, not so insofar as saying that the award is a nullity in that sense. My first case is very restricted. If order 21, rule 29 applies first, if it applies, then what is the course to be open to the executing court? 47 is made to that aspect. I am not contending that declared that the award is a nullity. Let us be very clear. Though it has been styled as 47, my scope of 47 is only to say that since there is a prior suit pending between the parties covering the self-same property, should the executing court proceed, or rather what should the executing court do at this stage? That is the only issue which is to be considered. Kindly consider 29. Stay of execution pending with suit between decree holder and judgment debtor. Madam, may I hand over this?
What?
CPC,
No, I have, yes. Order 21, rule 29.
Yes, yes. Where a suit is pending in any court against the holder of a decree of such court, or a decree which is being executed by such court, on the part of the person against whom the decree was passed, the court be on such terms as to security or otherwise as it thinks fit stay execution of the decree until the pending suit has been decided. So my 47 is very limited. I am saying if the provision of 2129 applies, then what is the role of the executing court? Here I say that all conditions of 2129 is being fulfilled. There is a suit pending. The award holder is the defendant in the suit concerning the property in respect of which he holds an award, which is being executed by the same court where the prior suit is pending. So these are the conditions. The court was required to say either Order 21 Rule 29 applies or does not apply. If it does not apply, plain and finish. If it applies, then what is the recourse to be taken by the executing court? This is the parameter of my application. It may be styled as 47. I have to come under 47 because 47 is why discharge, satisfaction, execution. In the process of execution, if I apply 2129, then it is a 47 application. I am not saying declare award nullity. All those points are not necessary here. But the learned judge has gone on that aspect. Now kindly see. So this first, page 14, the first criteria which the learned judge notices is not what I am placing at all.
Yes.
Whether the award debtor's case fall within the area of nullity or fraud, no. So section 116 need not be gone into. So here your lordship will kindly omit, turn over the pages because this is all discussion on 116. Ultimately, your lordship will kindly come to internal page 18.
Yes.
Under Order 2129. Here,
Yes.
under Order 2129, this court is vested with the discretion to stay execution of the award pending a decision in the prior civil suit between the same parties. But it is to state that such power of this court is discretionary and cannot be claimed as a matter of right by the award debtor. Perfect. Now, upon considering the aforesaid delineation, this court does not find any such case as made out by the award debtor so that this court shall execute such discretionary power vested under Order 21 Rule 9. There is no reason insofar as this is concerned. Then kindly see, it is reiterated that all such issues as raised by award debtor in IA 5 have already been taken into consideration by High Court in its order dated 20th of May 2016 in FMAT 744, relevant portion. Kindly let us see, my lord. This is, my lord, the judgment in the 37 appeal. Right? Judgment in the 37 appeal. In any case, it is a fundamental principle of law as enunciated in 64 and 65 of the Indian Contract Act that a party resigning a voidable contract is obliged to restore the benefit derived from the contract. Even if a contract is void ab initio, all benefits received thereunder would have to be restored. There cannot be dispute that even if it is assumed that Star Trek's agreement with Efcalon was voidable at the option of Star Trek was still obliged to restore all benefits which Star Trek derived from the license agreement. Now, with the greatest of respect, section 64, 65 of the Contract Act will not have any application right now. What does it say? That if our agreement is declared null and void, I will have to restore the benefit. I will have to restore the benefit to whom? So I will have to restore the benefit to the ultimate person. If my suit is decreed, that prior suit is decreed, rights will remain with KOPT. No other person can come in between. So today, even if I have to restore, even if I apply 64, the benefit restoration is being decided in this suit. The person who is entitled to be restored the benefits. This person will not be able to restore the benefit because he played a fraud. So, so therefore 64, 65 principle, even if applied, goes to the benefit of the suit. Then, my lord, kindly see, having been inducted by Efcalon, this is the point. Having been inducted, Star Trek cannot and does not have any independent right to occupy the premises, far less any right to let out. It is assumed that license agreement was void. the arbitration process start track would not be entitled to retain benefits derived. In other words, start track would have to refund occupation charges applied to whom? I would have to refund to the occupants. So here what will happen? He will get possession of a property which belongs to KOPT. Then, my lord, kindly see. So then it goes on to the concept of 116. So I do not know how this judgment, this observation can be relied upon in 2129 discussion. Then, my lord, your lordship kindly comes to page 21, where the quotation ends. The quotation ends at page 21 top.
Yes.
It is reiterated that while considering the instant applications, this court has also respectfully taken up the view of the Honorable High Court made on the judgment dated 22nd April FMAT such and such in respect of an application filed by award debtor under 37 of the. So I do not know how will it be relevant insofar as deciding applicability of 2129. He does not say it does not apply. He is now to decide how he will exercise his discretion. So that test, my lord, your lordship will not find here. Then, my lord, kindly see, apart from the above, it is to be stated that the instant execution proceeding has been proceeding in this court since long, and now it's proceeding in a very advanced stage to execute the award impute. Everything accepted. Can I not come at a late stage and invoke 2129? Only thing I will have to show the conditions that exist. Let him say that the conditions do not fulfill. As stated above, the award debtor has also stated in this proceeding that now the award debtor is not in possession of the subject property. But at this very stage, the award debtor has caused to file IA-5 alleging such grounds aforesaid. It is also.
What do you say to this finding? Award debtor is not in possession of the subject property.
But this is not correct. The receiver is there. My possession is there. Receiver is in symbolic possession. Receiver has been directed to collect all occupation charges, which I was initially collecting. Now the receiver is collecting from the occupation. So therefore, my possession, even if your lordship says that it was whenever it was illegal possession, but possession, I was in possession through ABCD collecting. That was their case. Now receiver is in charge collecting from ABCD. So my lord, it is not that I am not in possession. This is the principle, my lord. And at this very stage,
You are appointed in what proceeding?
In the section 9 proceedings, which culminated in the award, my lord. So in this arbitration proceeding, between us only receiver was appointed. Then, my lord, it is also reiterated the settled principle that an arbitral award which has attained finality cannot be subject to collateral challenge in execution proceeding. Again, my lord, we are going on the wrong way. This is not a challenge. This is a special provision. It is only the execution process is kept suspended. There is no challenge. This is not to be seen as a challenge. Because my prayer in 47 is not declare an award as a nullity. Cannot be subsumed. Again, this is extraneous to my application. And the scope of interference at the stage of enforcement, the execution court is not entitled to entertain, which is substantially sought to reopen the merits of the order. Where? After the challenge is settled, that execution cannot be converted for a review or because your lordship will not reconsider the award. The Honorable Apex Court in many decisions has held that the arbitrator will provide a complete code in his to challenge once the statute has been exhausted. The award must be enforced as a decree. In the instant case, award debtor has assailed impugned award. Very well, but then so this is the final finding. So where do your lordship find, with the greatest of respect, the reasons for refusing to exercise the discretion of 2129? Just one line, your lordship will kindly see. That page 18. Only one paragraph which says, but it is to state that under 2129.
Page 80, yes.
Under 2129.
Yes, but it is to state.
Yes, that is the only line. That such power of this court is discretionary.
So it's discretionary and not as a matter of right.
Right. Now, upon considering the aforesaid delineation, Now, what has he considered? He has considered the FMAT judgment, principle of 64.
So basically, the learned judge has observed that yes, it's a discretion.
I am not going to exercise discretion.
In your favor.
Why? Why?
In your favor.
I am sorry, my lord, but I say, where do I find the why here? If at all it can be found in the earlier paragraphs where she has quoted the FMAT observation relating to principle of 64, 65 and 116. But with my great respectful submission, that is not a ground to say I'm not exercising jurisdiction. In my respectful submission, the only line for refusing to exercise discretion can be to say that this suit, even if it is decreed, will not result or impair anyone's right if execution is proceeded with. Some nexus between the final outcome of the suit and the ultimate result of the execution proceeding has to be discussed and said that even if the suit proceeds and the suit is decreed, it will have no effect on the outcome of the execution. This finding is not there, but rather I am submitting, my lord, with the greatest of respect, that it will definitely have an impact. Today, a person will come into possession. So many things he will do in result. Naturally, he will do, which will render the decree otiose. The ultimate person who is the owner, who is there in court in this suit, he will have to, his rights will vanish. And that will only, my lord, engineer the fraud which has been pointed out. This my lord, this understanding between them is the outcome of fraud. So, my lord, a public authority has given the property to X, who will exploit the property, and that has been sought to be challenged in the suit, which is being pointed out to the executing court. Do not hand over the property to this other person. We are saying this. If there is a receiver already appointed, the receiver, let the receiver be in custody of the property. How the executing court could have come to this conclusion? The property is in safe hands. It is custody. It is not custodial legis because the receiver is in symbolic possession and only collection of rents. Let him be in custodial legis to the credit of the suit. Well, very often we say, in respect of money, if the money is lying deposited, it will lie deposited. No one will claim that. It will lie to the credit of the suit. So, my lord, that arrangement could definitely have been made. But what I say here is that there is no discussion on that. And the discussion which is there is actually extraneous to the application under 2129. It goes into the normal route of 47. The judgment debtor has come challenging an award in a circuitous way through the 47. This is not my case. My lord, dear lordship will kindly restrict my case to 2129 only. And my lord, incidentally, an order 7 rule 11 was filed by my learned friend's client for dismissal of the suit. That application has been dismissed. So the same court finds that the suit is a suit which is good to go to trial. And that we have pointed out that this suit is there. So in the meantime, don't give the property to them, X. So this could have been something could have been done. A arrangement could have been devised by the executing court. Yes, so I think these are short points. I would only request my learned friend to stick to this. I am aware of my consequences. There is a 37 which has gone, there is a SLP which has been dismissed. All is there. But there in the statute book, there is 47 for a limited purpose. And I am also exploring a further narrower compass of 47 to 2120. And I'm not going through the usual route of 47. I am not challenging the award on circuitous method. That order 7 rule 11 order is part of the petition.
Yes, Mr. Banerjee.
No, only a beautiful face, my lord, could have, my lord, pleaded such an ugly case. Only a beautiful face, my lord, could have pleaded such an ugly case. Tomaki. Kindly take
That's
note of
the
the
art of advocacy, Mr.
Yes, my lord, I was, my lord, learning. I was truly learning.
Yes.
Kindly take note of, my lord, some dates.
Dates.
My lord, my learned senior friend wanted me, my lord, wanted to preempt me, my lord, from indicating these dates. বসে পড়ে। My lord, the company which was the original lessee got, my lord, wound up on 21st December 1994. And, my lord, the properties of the company going into liquidation were sold to me, including, my lord, whatever interest the company had with regard to the subject land. That happened in December 1994. My lord, on 9th April 2003.
Yes.
I'll just take 5 minutes.
My lord, I indicate these dates, just, my lord, keep in the back of my lord's mind. My lord, the suit was instituted, which my learned senior friend was vociferous about, on 1st October 2015.
1st October
2015. The suit was instituted.
Suit by Mr. Sen's client.
Yes. My lord, the indigenous suit. 9th of April 2003, my lord, this honorable court issued a direction directing port to execute lease in my favor. Subject to me clearing all the arrear dues which were lying in arrear by, my lord, the company that had gone into liquidation. A question, my lord, then arose that, my lord, what would be meant by arrear dues? Would it be, my lord, in the recent rate or, my lord, in the past rate? My lord, we were of the view that, my lord, this should be past rate. KOPT was of the view, now, my lord, that has become Shyama Prasad Mukherjee put, that, my lord, should be at the revised rate. My lord, this issue as regards the direction issued upon KOPT to execute a lease in my favor travelled up to Honorable Supreme Court. Honorable Supreme Court directed KOPT to execute the lease deed, taking from me, my lord, rent at the revised rate. And the direction was to execute the lease deed from the date of, my lord, from, my lord, a retrospective date. My lord, I paid, lease deed was executed. So today, what is the subject matter of challenge in the suit is, my lord, an outcome of a direction issued by this honorable court, slightly modified by the Honorable Supreme Court. My lord, this deed was executed, which now, my lord, allegedly forms the subject matter of challenge in the so-called suit, is, my lord, implementation of the Honorable Supreme Court's direction in a judgment, which, my lord, possibly my learned senior friend has not brought to my lord's kind notice. Now, my learned senior friend started his argument today by saying, by, my lord, trying to create an impression that when the agreement for license was executed between me and my learned senior friend's client, my lord, I made a false impression. My lord, I gave a false representation that I am the lessee. My lord, that was the opening submission of my learned senior friend today. And with that, my lord, erroneous, my lord, representation, I induced him, my lord, to get the property from me. My lord, I will take your lordship to the agreement for license. My lord, that was not the representation. All the litigations, everything, the exact status was disclosed in the recital of the agreement. So, my lord, he took the property from me in lieu of a monthly license fee of few lakhs of rupees. After coming to learn, my lord, where the property stands, where I stand. Then, my lord, that agreement between me and my learned senior friend, my lord, that contained an arbitration clause. Milord, the license was for a limited period. Then, Milord, with a renewal clause, providing for a renewal at my discretion, again for a limited period. Milord, this extended time, even if I assume that, Milord, there was a renewal which was not there, has expired decades back. Today, Milord, he is trying to protect an interest which is beyond contract, which is beyond Supreme Court's order. Now, Milord, he suffered an award, eviction. Milord, interim award and award, Milord, there is no difference. So, Milord, I call it an award. It's under section 31, subsection 6. Milord, before the learned arbitrator, it was a point whether, Milord, I had a locus to sue him because of my alleged defective list deed. Point was decided. It bush na. What it bush is that? Facte bhul bolle bhul gina lena. Point was decided. That was challenged in 34. He was shown the door, including on this point. My locus. Milord, sustainability of my deed, legality of my deed executed by KOPT in terms of the directions issued by the Honorable Supreme Court. So he lost the point before Milord arbitrator. 34, 37, SLP. Milord, before the Honorable Supreme Court, when Milord they took up Milord this matter, carried this matter to the Honorable Supreme Court, the Honorable Supreme Court was of the view that they can have a chance to be heard, provided provided Milord he puts in 25 crore. The moment Milord this condition was put, they withdrew themselves from the SLP. And this all happened post institution of the suit. So, Milord, whether or not the deed is valid, which is created in my favor, firstly, Milord, that's a product, but that's a baby of the Honorable Supreme Court. First. Second, Milord, thrice this has been tested. Learned arbitrator, 34 court, 37 court, Supreme Court. And in course of pendency of the suit. Now that I get an award, Milord, I try to execute the award, Milord, to get him evicted. He files this 47 application. Today, Milord, my learned senior friend has suggested, let us not treat this as section 47. Let us treat this as order 21, rule 29 application. Milord, the moment my learned senior friend suggests this, Milord, that should be the last nail to his coffin. Milord, order 21, rule 29 is clear. It says, Milord, if he has suffered a decree passed by the court, now, Milord, an award is executed as if the award is a decree. So, Milord, it's a deemed decree. Milord, all of us have learned this, Milord, from a matter done by Mr. Mukherjee, Mr. Shaktinath Mukherjee. Milord, what's the difference between, Milord, something which is, Milord, exists and which, Milord, exists because of a deeming fiction in law. The moment I called something a deemed decree, I accept it's not a decree. That's why I called it a deemed decree. So it's a fiction. So, Milord, order 21, rule 29 is not his cup of tea at all.
According to you, it's not maintainable.
That's why
it's not
my
a decree, but
maintainability application.
It's a deemed decree.
So if he is not taking recourse to 47, Milord, he is out of the court immediately. Let my learned senior friend show one decision of any court of law that, Milord, an award debtor, not a judgment debtor as such, an award debtor can take, Milord, refuge under order 21, rule 29. Now, Milord, what is the scope? Milord, let me now also assume, Milord, against me that order 21, rule 29 applies. Where the wordings of order 29 rule 29 order 21 is this, that Milord, if there is a decree or Milord, the decree is put into execution, the person who suffered decree, if he has a previous suit, then the court may stay, Milord, further proceedings in the execution. Milord, let us read this provision with subsection 3 of section 8 of the 1996 Arbitration and Conciliation Act. Subsection 3 of section 8 says, Milord, even if there is a suit, even if Milord section 8 is not allowed, arbitration can proceed between the same parties on the same cause of action and an award can be passed. So, Milord, if we read Milord, order 21 rule 29 and subsection 3 of section 8, it will be all the more clear that Milord, order 21 rule 29 was not meant for an award debtor, it was meant for a judgment debtor. Classically, in the classical term, Milord, for a judgment debtor. Milord, had it not been so, subsection 3 of section 8 of the 96 Act would never have been there. And Milord, 96 Act is post 1908.
Yes.
So, Milord, what he is actually trying to do is, Milord, to reopen and re-agitate the issues which have been decided, confirmed, reconfirmed, reaffirmed. He wants to open it. And he says, court did not open up its mind, saying why the court is reluctant to, Milord, use the discretion. Milord, court has held that this is not maintainable. Milord, after the court was of the opinion that this is not maintainable, there was no question of exercise of discretion.
Where it has been held?
Milord, I will take your lordship to that. Which is why my application was allowed. My maintainability application was allowed. Milord, I just indicated, Milord, before Mr. Sen started, that 2 applications, common order. The second was my maintainability application. Now, Milord, keep this, all this, kindly keep all these things, Milord, aside. Milord, there is a suit. Let us, Milord, just consider there is a suit. Milord, what is the subject matter of the suit? I will take your lordship to those pages. Milord, we have 2 deeds now in hands. One is by KOPT in my favor. One is by me in his favor. What is under challenge is not, Milord, the deed by me in his favor. That's not the subject matter of challenge in the suit. And he has suffered, Milord, an eviction decree, the agreement between me and him, which is not subject matter of challenge in the suit. What is under challenge is the deed between KOPT and me. Let me assume that, Milord, he succeeds in the suit. Milord, by succeeding in the suit, by getting a decree, he cannot get rid of the award. Milord, the prerequisite of Order 21, Rule 29 is that, Milord, it should be, Milord, knitted in the same thread. Can't be, Milord, parallel. So, Milord, today, even if he succeeds in the suit, Milord, he can't stop execution because he is admittedly claiming under me, the property. So, Milord, 116 is squarely applicable. He is trying to, Milord, portray a case, is trying to, Milord, create an impression in my lord's mind that, Milord, I am a stranger to the property. Milord, that's his best possible case. And his best possible case is best possible status is he is someone inducted by a stranger. So how can Milord, may I ask myself, jump over me, Milord, to get to the grassland? He can't do that. Milord, there is, Milord, a debarment by law. And everywhere, before every court of law, before the learned arbitrator, everywhere, Milord, he has admitted that he is claiming under me. He could not have been, Milord, in possession of the property for a single minute had, Milord, this agreement been not there. So that is only source of any semblance of interest in the property. He is not challenging that. He is wise enough, not challenging that. He is challenging what, Milord, precedes that. Milord, if that gets demolished, Milord, the agreement between us, Milord, can't be sustained. And the moment, Milord, he accepts that, Milord, it was me who inducted him, and this being, Milord, a registered lease, this being, Milord, a pursuant a notice under 106, Milord, section 108 of the Transfer of Property Act. Milord, he has to make over possession not to the superior landlord, but to me. Section 108 of, Milord, the Transfer of Property Act. So, Milord, if Milord looks at this matter from whatever angle, Milord, he doesn't have a case. Milord, if today I file a suit, I do not proceed with the suit, and Milord, try to stall an arbitral award for decades, Milord, Order 21, Rule 29 cannot, Milord, come, Milord, to his rescue. Milord, that can't be the spirit of, Milord, Order 21, Rule 29. And 47, Milord, today, for the first time, they are giving up because they know that, Milord, 47 is only to show that, Milord, the decree is a nullity, without jurisdiction, void. They are not saying that, Milord, they have accepted the position today. That 47, they are not, Milord, even arguing before your lordship. So I'm not troubling, Milord. I was armed with, Milord, so many 47 decisions. I need not trouble your lordship. Now, when it comes to arbitration, Milord, the Honorable Supreme Court has drawn a distinction between, Milord, this exercise of 47. Though, Milord, they are not arguing 47, I, Milord, cannot, this is my temptation. Milord, the Honorable Supreme Court has held in, Milord, some Shah, ki Shah? Rahul S. Shah matter. That, Milord, when it comes to an award, and a 47 is filed in an execution proceeding arisen from an arbitral award, Milord, the scope of 47 is limited to the extent of showing that the decree is void. Now, Milord, kindly also look at this matter from another angle. Here is a licensee. Milord, let me now call him a sublessee. He is not a sublessee. But, Milord, for the sake of better understanding, here is a sublessee who says that the lessee did a fraud with me. That's his case according to him in the suit. Fraud. He has not even pleaded fraud in the plaint. Milord, I'll show that. Fraud is not even pleaded. For to speak of, Milord, particulars of fraud being given. So that was wrong submission. I'll show, Milord, from the plaint. Let me assume, Milord, let me assume everything against me. Sublessee is saying that, Milord, in his induction was a product of fraud. Because, Milord, if my induction was a product of fraud, Milord, he is a scapegoat. His induction is also a product of fraud. Milord, if that be so, then, Milord, section 64 of the Transfer of Property Act requires him, Milord, to first restore all the benefits, Milord, that he has so far received, Milord, from a fraudulent contract. Milord, what are the benefits he have received? Milord, there was a tentative calculation, orthodox assessment by the Honorable Supreme Court then at 25 crore. Then, Milord, section 65 says of the Contract Act, he cannot retain the benefit. Same thing, 64, 65 Contract Act, same. So, if he is calling this void, or my lord even voidable at his instance. What he must do, he must first restore the benefits. Before he does so, Miller, it's not, Miller, he cannot open his mouth too wide to say that Miller KOPT did a wrong to me. And the moment he says that KOPT ought not to have done this because this is violative of Section 34 of the Major Port Trust Act, the only forum available to him is the Honorable Supreme Court, whose order was implemented by executing the list. He is then Miller questioning the wisdom of the Honorable Supreme Court because Miller, the trade it was a judgment, not Miller a one-line dismissal of SLP. A judgment was delivered by the Honorable Supreme Court. I will show to your Lordship the line by line. But he is not questioning that order, no review, no curative. So, Miller, he is accepting the Honorable Apex Court's order that there is a direction upon KOPT to execute a lease deed upon acceptance of rent at the revised rate. That is what has been done. And it is not his case that, Miller, the lease deed has been executed in breach of Supreme Court's order. My learned senior friend has not even argued this today. He has not uttered a single sentence on this. That's not his case. Could not have been his case because, Milord, the suit he filed, Milord, in 2010, and Milord, the Supreme Court's order, Milord, came, yes, in 2006. So, Milord, he knew, but did not, Milord, threw any challenge or questioned or doubted, Milord, the integrity or wisdom of the Honorable Supreme Court. So, Milord, and my learned friend was also, my learned senior friend, Milord, was also, Milord, drawing my Lord's attention to my demerit application, which has been, Milord, dismissed. So, Milord, my learned friend, Milord, commented that the learned trial court is of the view that there is a tribal issue. That's even that, Milord, submission is not correct, factually not correct. Milord, mine was, though captioned as, not even captioned as a 711 application. It was not, Milord, an application for rejection of plaint. It was an application for dismissal of suit under Section 151 because of subsequent events. Because now, Milord, the Honorable Supreme Court has widened the scope of the learned trial courts to dismiss a suit if the learned court feels that because of subsequent developments, nothing remains in the suit. Milord, we suffered a defeat in Section 151. But, Milord, that does not necessarily mean, Milord, the learned trial court, by dismissing a 711 application, has been of the view that there are tribal issues. And, Milord, dismissal of my 711 application, which, Milord, we are thinking of, Milord, filing a revisional application therefrom, Milord, does not come to his aid, Milord, in his Order 21, Rule 29 application. Because the subject matters are different. The suit challenges the deed between me and KOPT. He gets an eviction award, suffers an eviction award on the strength of, Milord, the agreement between us, which is not under challenge. Now, Milord, kindly have a look at the plaint first. Page, Milord, 131. Yes. Milord, 126, Milord, it starts. Kindly, Milord, turn to page 131, paragraph 8. Should I, Milord, read it aloud? Yes. Plaintiff further states that even before the said order of the Supreme Court of India was made, the defendant number 1 entered into an agreement with the plaintiff on or about 26 December 2004, whereby the plaintiff was inducted into the suit premises at such and such. hereinafter referred to as the said premises for rents mentioned therein commencing from such and expiring in October 2011. Admitted position. So, my lord, he always knew that, my lord, the deed is not there in my favor. Even before the Supreme Court order directing KOPT to execute lease deed, he was put into possession, inducted by me for a limited period in lieu of rent, which also, my lord, he did not pay, which was a ground, my lord, for his eviction award. And he, my lord, inducted subtenants and, my lord, crores of rupees every month. Did not pay me, my lord, lakh. And he today has the courage, my lord, to file Order 21, Rule 29 application. Then, my lord, kindly turn over the page. Paragraph 10, last 3 lines. Such payment has been made by the defendant number 1 till the month of such and such. In December 2009, the plaintiff came to know that the defendant number 1 has not paid any rent to the defendant number 8, Kolkata Port Trust, and the defendant number 1 to provide the statute details of payment. Some details of payment. Kindly see, my lord, the misleading statement. He knows that, my lord, the deed was executed by KOPT in my favor in 2015, 23rd June 2015. He is suing me in 2010, saying that rent has not been paid. Then kindly, my lord, take the last 4-5 lines of the same page. It becomes apparent to the plaintiff at the time that the recital of the said agreement that the defendant number 1 claim of payment of the entire arrear rent amounts to the Kolkata Port Trust is false. The said recital was made on the basis of false representation made by the defendant number 1 to the plaintiff. Furthermore, the defendant number 1 committed a breach of its fundamental obligation under the contract to pay all rents, etc., etc. Kindly pause here for a moment. So, what is the complaint? That I defrauded him by entering into the agreement with him. So, my lord, what is the product of fraud? As per, my lord, my humble understanding is the agreement between us. And it is on the basis of this allegation, what he challenges is not this agreement. The agreement between KOPT and me. Kindly turn to the, my lord, prayer question. My lord must have seen, my lord, the movie A Beautiful Mind. My lord, the prayer is at page 142. Prayer A. A decree for declaration that the plaintiff has a right to enjoy the said premises. My lord, it will shock the conscience, my lord, of anyone. He is saying that, my lord, the agreement between us is a product of fraud, but he has a right to enjoy the property, though I do not have. And he is claiming under me. And he is citing, my lord, this suit to stall, my lord, the execution procedure. Then, my lord, kindly come back to the averments again. So he says, agreement between us is a product of fraud, but that should survive. What should go is the previous debt. My lord, that's how, my lord, the plaintiff is couched. Then, my lord, kindly come back to page 134.
Yes.
Paragraph 14 at the foot of, my lord, page 134. The plaintiff states that the plaintiff, relying upon the aforesaid, I made, my lord, fraudulent representations to him, according to him, relying upon the aforesaid representations and believing the same to be true, entered into an agreement dated 26 December 2004. Such agreement was entered into by the plaintiff being induced by misrepresentations made by the respondent, defendant number 1, that the Kolkata Port Trust, the defendant number 2, has agreed to renew the lease in favor of the defendant number 1, passed by the Honorable Division, in terms of the order passed by the Honorable Division Bench in view of arrear of lease rent payable by the defendant number 1 was duly cleared. So, my lord, he says again that 26 December 2004 is the instrument which is a product of misrepresentation, but he challenges, my lord, an instrument of some other instrument of, my lord, 2015. Then, my lord, paragraph 15. The plaintiff states that the plaintiff has been constrained to stop payments. Can we see, my lord, his courage? So, my lord, he has detected a fraud, and the product of fraud is the agreement between us. So, he do not want to, my lord, discharge his duties under a fraudulent agreement, but he is keen, my lord, to reap the benefits under the fraudulent agreement. Section 64, Section 65 of the Contract Act, my lord, stare at him. The plaintiff states that the plaintiff has been constrained to stop payment of rent after September 2010. When the plaintiff came to know that the defendant number 1 had never has any right at all in the said premises, the Honorable Supreme Court passed the order in 2006. So, he knew the order. And he's saying he stopped in 2010 at all in the said premises. In fact, the representations made by the defendant number 1 at or upon execution of the said agreement, Miller, is in the entire body of the plaint, he is talking about the agreement between us. Upon execution of the said agreement is entirely false, as would appear, my lord. So many reasons are given qua the agreement between us. Then, my lord, kindly turn to the next page. Paragraph 17. I wish, my lord, this petitioner had borrowed the wisdom of Mr. Shen prior to drafting the plaint. Paragraph 17, last 3 lines. Plaintiff further states that without fulfilling its reciprocal obligation, the defendant number 1 was not entitled to realize rent from the plaintiff. Kindly see, my lord, the statement. He says, unless I pay to KOPT, which according to him I was not paying, I cannot take rent from him. But he, as per the prayer, has a right to remain in possession, claiming under me in the property for eternity. That's what is the suit about. Then, my lord, 1 or 2 more statements in the plaint. Kindly turn to, my lord, page 137. Kindly read, my lord, from the second line towards the right hand side. Now he says he is entitled to, my lord, get back all the money which he has paid to me, whatever peanut amounts, my lord, he has paid to me. The plaintiff further states and submits that the plaintiff is now entitled to receive back the entire amount as to meet the liabilities of KOPT. My lord, he doesn't owe any liability to KOPT. There's no privy between him and KOPT. And Kolkata Municipal Corporation. If such payment is received from the defendant number 1, me, my lord, the plaintiff is willing to pay the entire amount towards liquidation of the dues of KOPT and KMC. Since the defendant number 1 is not paying the dues of KOPT, defendant number 1 is not entitled to release the amount from the plaintiff. Subtenant is saying tenant is not paying to the superior landlord, why should I pay you? And that is what the suit is all about. And with these averments, my lord, he say the superior landlord ought not to have inducted the tenant. Which is why, my lord, I was saying, my lord, a cost, my lord, now time has come, my lord, for imposition of a cost, for, my lord, wastage of this time, of judicious time, my lord, in every forum. Till such payment, page 137.
Taken 10 minutes of your lordship's time.
Mr. Shen's 10 minutes, my lord, is equivalent to my 10 years. Mr. Shen's 10 minutes, because of his vast experience, is equivalent to 10 years of my life.
According to Mr. Banerjee, should not have been given 1 minute only.
But that
The case was such,
no,
according to him.
to satisfy your lordship on that, he is taking 1 hour. That my case does not involve 1 minute of time. He requires 1 hour time.
তুমি ওদিকে মন বেশি কথা বলছিস কেন? Till such payment is made by the defendant number 1, the plaintiff is released from its obligation from making payment to the defendant number 1, and the plaintiff is accumulating that money. Milord, he is keeping that money safe so that the same can be paid to
Wants
KPT.
to pay it to the Kolkata Port Trust and Kolkata Corporation.
And when Milord Supreme Court asked him to pay, Milord, he withdrew himself from SLP. I'll show that. Milord, he is keeping money somewhere. Some hidden gems are there, hidden treasures. Milord, kindly turn to page 139. Milord, this is the only straw which Milord, this drowning petitioner is now trying to catch at. So, Milord, I'm just Milord showing the straw which Milord he has in his hand today. 139. Milord, last 8 to 10 lines. Milord, Milord starts with on the left hand side for the year 2015.
Yes.
I'm grateful, Milord. For the year 2015 and defendant number 5, as a representative of defendant number 1, executed as a lessee, plaintiff states that the said deed is illegal, invalid, collusive, and void deed, as because the defendant number 2 never had any right to execute the said lease deed without following policy guidelines of land management by major ports 2014, and as such, defendant number 1 never acquired, can you mark this? Never acquired any right title interest in the suit property, nor were in possession of the said property, at any point of time. Not only that, there is no whisper in the said deed in respect of handover of possession to the defendant number 1 and the said property at such and such, to till date in physical possession, 2005 till date in physical possession of the plaintiff, and till date paid rent to the defendant number 2, the Kolkata Port Trust, in respect of the premises, and the defendant number 2 acknowledges receipt for such payment by encashment checks, and as such, alleged deed created by the defendant number 2 in favor of the defendant number 1 is also illegal, invalid, collusive, forged. He says, Milord, I am accumulating money. If called on, I will pay to KPT. All of a sudden, a twist. Milord, after gap of a page, he says he is paying to KPT, which is factually incorrect.
Paying to KPT?
Yes, it's here. Can you, Milord, again read this? Milord, the sentence starts, Milord, at the bottom of the previous page. Let us read. Yes.
Acknowledge receipt for such payment.
Let him show. The previous paragraph, he has said he is willing to pay to KPT.
This entire sentence has to be read. Can you see?
Yes, Milord, let us read this. Milord, the sentence.
As such, defendant number 1 never acquired any right title
Correct.
nor were in possession of the said property.
So I was never in possession. That's his case.
Yes. Not only that, there is no whisper.
Correct.
In the said deed in respect of handover of possession to defendant number 1 and the said property at such and such, since to date in physical possession paid rent to defendant number 2, Kolkata Port Trust. That is, from here, there is no whisper that they have been paying rent to the defendant number 1 KOPT. It is not about us. We are talking about the lease deed. There is nothing mentioned in the lease deed about their possession, about their
Milord, if this sentence is constructed in that way, then Milord, I have even a better case. Milord, I will then show Milord his own deed. Milord, let us construe it in that way. Milord, I am so grateful to my learned senior friend. Let me construe this, Milord, in the way my learned senior friend has construed this.
Then, my lord, kindly skip over 2 lines. The plaintiff thereafter he obtained certified copy of the deed from the registered office and came to know all fraudulent acts of the defendants in details, and as such the plaintiff has been compelled to come before this learned court praying for a decree for declaration that the plaintiff has a right to enjoy the property with etc without creating any obstruction, hindrance, etc. Then, my lord, the prayer portion, my lord has seen at page 142. Now, my lord, kindly let us see, my lord, the instrument executed with him, my lord, that is at page 75. He says, my lord, he has been defrauded. He was not made known, my lord, of the facts. Page 75. My lord, the recital starts at page 76. My lord, every bit of facts is indicated in the recital. Clause A at page 76. My lord, the company asked original lessee going into liquidation. My lord, clause B, property sold to me. Clause C, my lord, when the lease of the original lessee expired. Clause D, my lord, KPT was not renewing. Clause E, my lord, the order sending the company to liquidation. F, my lord, I am purchasing the property in court. G, division bench, my lord, directs KPT to execute a lease deed. Then, my lord, H, kindly have a look. The opening submission of my learned senior friend on instruction before your lordship today was that I made an impression, a false representation that I have become a lessee. Kindly see, my lord, clause H. So the instruction my learned senior friend has received is belied by document signed by him. And kindly, my lord, recollect the statements, amendments just now, my lord, have seen, my lord, in the plaint that I was never been in possession. Kindly see, my lord, clause H again. Then, my lord, kindly turn to the next page. Kindly see the limited tenure he was put in for as a licensee. Expired in, my lord, 2014. Even the extended period, though there was no renewal.
Yes.
Now, my lord, the Honorable Supreme Court's decision. My lord, that is there at page 67. My lord, what gave birth to the lease deed, which according to my learned senior friend is fraudulent. And my lord has not seen, my lord, the particulars of fraud. My lord, the deed between me and KOPT. In, my lord, the plain. Page 67, my lord, kindly turns to now. My lord, this is an order passed, judgment, my lord, delivered by the Honorable Apex Court on 8th of May, 2006. Kindly take, my lord, the 5th paragraph at page 68. The High Court has, my lord, kindly got it. The High Court, while deciding on this matter on 1st December 2004, my lord, was inducted on 26 December 2004, where, my lord, in the recital, the High Court order was, my lord, referred to. Allowed the claim of the respondents and thereby ordered the port trust that upon the respondent, my lord, I was the respondent because it was, my lord, their SLP. Upon the respondent clearing all the outstanding rental dues and taxes, the port trust shall grant fresh lease in consonance with the lease indenture that existed between port trust and Dash, etc. So, my lord, that was carried by KOPT in appeal. Kindly, my lord, straightway come to, I will not, my lord, waste my lord's time unnecessarily. Kindly turn to, my lord, page 72. And he says, In his plaint, the foundational statement of his plaint is, I was never in possession. Page 72, third paragraph, starts with, the fact remains. The fact remains that the respondent number 1 company remained in possession of the property. Demolishes the foundational statement of his plaint. It has now come to the knowledge of the Port Trust that despite the fact that no right over the property existed in favor of the respondent number 1, they are not only carrying on unauthorized construction in the premises, but have also parted with possession to various individuals, companies not connected with their main business, and are extracting third-party rights, which includes, my learned friend also. Such construction and part, etc. We cannot also at the same time close our eyes to the realities. We have therefore to safeguard the interest of the Port Trust, the interest of the first respondent, and the workmen of our stock, etc. Kindly see the ordering portion now. Kindly turn to page 73. The last 3 lines of the continuing paragraph. The Port Trust itself allowed the erstwhile lessee to continue to occupy a property even after expiry of the original terms of the lease. In our view, the workmen of the company have a right. Then skipping over 4 lines, the Port Trust has never called upon the company or the official liquidator to vacate the property. The act of Port Trust in allowing the respondent to continue is only a benevolent act. Then special justice, next paragraph. In conclusion, penultimate paragraph, we order a fresh lease indenture to be drawn from the date of the company came into possession of the land, that is from 4th August 2003, and he was put in possession in 2004. We are not here to decide, adjudicate upon, or to draw kind attention to the wisdom of the Honorable Supreme Court. It's not a forum to test the Honorable Apex Court to its from, not the learned trial court was the forum for that. The company case into possession of the land between the Port Trust and the respondent number 1 with regard to the premises situated and such. We are therefore directing Port Trust to inform F. Calon, myself, of the rental arrears together with interest. If that is paid, then deed is to be executed. And that is what was done. Now, arbitration started, the agreement between us. Kindly see, the award at page 149.
So, Banerjee, how much time?
I need to show at every stage. The issue was 15 minutes more, 15 to 20 minutes more. Can come back tomorrow. 20 minutes more, if this be the first matter, second matter, subject to minutes convenience.
But if it may be at 12 noon, possible. Morning, I am in some difficult
Any time which is.
All right, if you are difficulty, because Mr. Banerjee will be arguing, will be giving a reply.
Yes.
Ask your juniors to remain. If you are do not come by that time, I will come. Heard Mr. Shane Larned. কালকে না টিপিএম করবেন না।
Matter, my lord. I am each and every day's delay is having heavily counting on me, my lord. Kindly consider, my lord.
All right. You have mentioned.
Yes, but you have not kindly. If you are giving a fixed date, or else, or in the alternate, if I understand it's a heavily loaded court is heavily loaded. In the alternate, if your my lord is unable to means for an expeditious hearing, kindly I consider for release, my lord. Kindly.
Anytime.
Fixing a time tomorrow might be a problem. Let me see. Please keep a watch. Tomorrow anything is going to happen?
No.
No resolution.
I heard a lot of things has happened in Bar Association room number 11.
Today? Is it so? I'm not aware.
I'll get to